Okay.
Your Honor, my
Yes.
name is Clarissa Keel, and I need to request a continuance. I've been unable to get my husband served, and I need to file, I believe I need to file a motion to have him email served.
Okay. So let me just call the case. Thank you, Ms. Keel. This is the Clarissa Keel and Devin Keith matter. I did note that when in reviewing the case, it looks like there was not proof of service that has been filed. So there is a temporary restraining order that's in place. What is your expectation, Ms. Keel, as far as timeframes to serve Mr. Keith?
If I could file the motion to have him email served, I could have him served, and then within 2 weeks.
So your request is 2 weeks?
Yeah, he avoids service.
Okay, just one moment. I'm fine with that continuance based on the non-service. Let me just pull up the. Let's see. Just one moment. To the person who's calling in on it's the titled Schumann family. Is that Arthur Sherman and Astrid Schumann? Okay, so let me just take a moment to reissue the temporary protection order that was noted for today. Okay, I've signed that reissuance of the temporary restraining order. And I've set the matter for Wednesday, June 26th at 9 a.m. So we'll see everybody at that date and time.
Okay, thank you so much.
Thanks.
My name is Jeanette Erb, and this is regarding the case between Erb and Andrews for contempt of court. And I'm going to drop the case at this time.
Okay, so it was noted for a motion for contempt, correct?
Yes.
And it looks like I didn't see proof of service that you served Mr. Andrews with the paperwork. Is that accurate?
Signed letter, certified mail.
Okay. And so notwithstanding that service that you have, that you're asking that the motion be withdrawn?
Yes, sir.
Okay. And I'll ask if Gregory Andrews is on the line or present in the courtroom.
Okay.
Oh, Mr. Andrews. Okay. Come on up. Any objection to the motion being withdrawn?
I do not, sir.
Okay. So I guess what I'll do, since the motion has been filed, I'll just simply deny the motion. And I'll do a brief bench order to that effect. It says the motion filed on such and such a date is hereby denied.
Thank you, Your Honor.
Any concerns with that? I'll take a moment to do that right now. It's just probably a little bit easier. So it's kind of that sense of Americanness, having the immediacy of things. So let me just hurry and just write that out. And I'll just give you a copy so you can have it for your records.
Hey, yes. Ben, we skipping 6? Whoa. No.
Mr. James, Brandon James, friendly reminder to you to mute your phone.
Sorry, Your Honor.
Copy for each of you that's dismissing the motion for contempt, and then the original will be filed with the court. Any questions either of you have?
No, thank you.
Okay, all right, thank you.
Your Honor, I'd like to request a continuance.
Okay, tell me your name, please.
Brandon James.
Thanks, Mr. James. One moment, I'll call your case. All right, this is Monique O'Brien and Brandon James. We're on today for a presentation of from the order for the hearing on May 8th. I'll ask if Monique O'Brien is on the line.
I'm here.
Okay, you're present. All right, and then Mr. James, tell me the basis of your request to continue today's hearing.
I broke a tooth last night, and a dentist said that they could get me in for emergency surgery.
Okay. And Ms. O'Brien, what's your input related to the request to continue the matter?
I just want it over with.
Okay. So let me just double check. Looking through my file in which proposed orders have been submitted. Let's pull them up here. All right. And then let me double check with you, Mr. James. It looks like Ms. O'Brien prepared a proposed parenting plan based on our hearing from May 8th. Did you receive a copy of that?
I got an email of it.
We got an email of it. Okay. And when you looked over it, did you have any objections, meaning that Ms. O'Brien did not accurately capture or reflect what the court had ordered?
A couple.
Okay. And As far as your request to continue, those items, those couple items that you saw in the parenting plan, are those items that you could address this morning? And I'm I don't mean to be unduly unyielding in the request to continue, but I'm just wondering if we could just take care of it today.
Yeah.
Okay. So then, Mr. James, can you tell me, when looking at that parenting plan, where your areas of disagreement are, where you feel that she didn't get it right?
I just don't agree with her having majority custody,
Okay.
considering the fact that she admitted that that space is not healthy and she wants to put her back into it.
Okay. But besides the clear disagreement with the court's order, as far as the custody and the like, are there specific items where the court had ordered X, Y, or Z, and Ms. O'Brien put X, Y, and C or D, or got it wrong what the court had ordered?
No.
Okay. So the parenting plan here shows joint decision making between the parties for healthcare and school and educational issues. Ms. O'Brien is nominated as the primary custodial parent, and Mr. James has kind of that tiered approach, tiered custody for kind of the 2 weeks, and then another 2-week period, and then another 2-week period. Then it goes to the week on, week off. And so here she has written 2 4-hour visits each week for 2 weeks, then 1 4-hour visit and 1 all-day visit for additional 2 weeks, then 1 overnight visit for 2 weeks, and then week on, week off schedule. That looks like that's in accord with what the court ordered back on May 8th. So that seems fine. And then there's some midweek visits that are included for Mr. James. And then it talks about the summertime and then holidays. Any concerns with any of those, Mr. James?
No.
Okay. All right. So I think it's based on our just brief discussion here today, I'll deny the request to continue the matter based on the input from Mr. James and Ms. O'Brien, and I'll sign that proposed order as it fairly reflects what the court had ordered previously. So if either party needs a copy of this order, I didn't make any alterations to it. I've signed it as presented. You can check with the clerk's office and get a copy of it. Any questions, Mr. James or Ms. O'Brien?
No,
So when does it start?
So I think it's the effective date is today. It's signed today, so that should commence today as far as the effectiveness of the order. Okay, Ms. O'Brien, did you have any questions?
No.
Okay, unless there's any other questions, that'll conclude today's hearing. Thank you. Represents Ms. Ellis. Is William Ball on the line?
Good morning, Your Honor.
All right, good morning, Mr. Ball. And is John Ellis on the line this morning? Mr. Ellis?
I am, Your Honor.
Okay, welcome to you. And I see Ms. Turnbull is present, the guardian ad litem. Let me take a moment to grab the proposed orders. Yeah, first off, it looks like Mr. Ball prepared and submitted two proposed orders. One is a temporary family law order. The other is a parenting plan order. I'll ask if Mr. Ellis, if you received a copy of those documents.
I received a copy of those documents, but those were not what was on for presentation.
Okay, and Ms. Turnbull, did you receive a copy of those proposed orders?
Yes.
Okay. All right, let me follow up with Mr. Ellis. You had submitted some additional information after the hearing, and let me just pull that up here. So so this is from our hearing back on May 8th, where the court adopted pretty much in full the recommendations of the guardian ad litem. And the parenting plan, let's take a first look at that. I'll ask Mr. Ellis, in looking at the parenting plan, are there areas within that parenting plan order that you feel do not accurately reflect what the court had ordered back on May 8th?
Yes, sir. And first off, I would like to understand, because we pulled the transcripts, and although there was discussion about the guardian ad litem's recommendations, and I even proposed that I would be open to that, that wasn't part of your order. So I did take issue with some of those inclusions. But the parenting plan that the opposing counsel has proposed also falls under line. Over a year ago, I did just this exact same thing. I submitted a proposed parenting plan in response to a petitioner's hearing on a motion, and this court ruled that a proposed parenting plan would need its own motion and its own hearing, and it would not hear it. And that's exactly what he's done in this case. But in his proposal for presentation, he has completely substituted his own parenting plan instead of modifying the existing parenting plan with just the changes that you've ordered. Specifically, in section 3, our existing parenting plan has always left the reasons that a court must and reasons that a court may put limitations on a parent from reserved to claiming that there are 191 factors. They falsely listed in section 3 that the respondent must be limited due to 191 factors, claiming the respondent was found to have committed domestic violence per RCW 7105-010, and that I had no emotional ties to at least one of the children. Both of these are unfounded allegations that were reserved by the court during the initial petition for temporary family law and protection order over a year ago. The subsequent DV evaluation only recommended that if I did not complete a 9-month DV intervention treatment, that I would be likely to escalate to DV. The DV evaluator did not find that I had committed acts of DV and is willing to write a letter to the court clarifying this. Additionally, the DVIT program that was completed has prepared me to respond appropriately in these situations and further lowers the risk of reoffending, not raises it. My motion on the previous hearing in May asked for those reserve sections to be changed to not present, whereas the prepared orders have taken it from reserved to mandatory restrictions upon the hearing or upon the parent without any hearing or court order finding this to be true. Additionally, the lack of emotional ties was never in the original proposal by the petitioner, nor has it ever been any more than reserved in all orders. And the lack of ties is not from myself to the children, but from a child toward myself. I've never stopped loving, reaching out to, and caring for the children, even though some are rejecting me in this process. And this section too should be left reserved or not present. You did not order on that, and he has made the change. Additionally, he has completely changed out section 14, which is the other section. Our existing parenting plan had some of that verbiage proposed initially, and the petitioner abused it. She scheduled the children to have extracurricular activities that interfered with the parenting time by father, and those were never adopted into the parenting plan. He's again proposing that this be allowed and that it would take precedence over the parenting time. I see nothing in your order that related to section 14, and so it should be left exactly as it was in the existing order. Similarly, he's put in a holiday schedule, which he's asked me if I would please agree to. I cannot agree to a holiday schedule of 3 changes a year when I don't have unsupervised visits with all of my children, because as it is right now, I have not been able to take any of my children on a vacation for 2 years, and even my little ones, the longest I can go is 2 days. My proposal, which you didn't order, but my proposal asked that we have a 2-week summer vacation as the only change to the weekly visits. And then, of course, as you read in my subsequent declaration, I feel that the court was trying to help in giving the children back additional time with the respondent, but inadvertently has done the opposite by taking the preschool age children from seeing father every what was a few days initially to 7 days. They realized that was a mistake. They reeled it back to every like 4th or 5th day. Now it's all the way out to 14 days. 14 days between a preschool set of preschool age children seeing either one of the parents. And I don't believe that that's in the best interest of the children, but it was your ruling. Regardless, I would ask that the court not do what unusually happened at the last hearing, and that is allow opposing counsel to prepare the presentation on the other party's motion.
Thank you, Mr. Elson. Let me ask you just a brief follow-up question on that last point. Did you submit any proposed orders?
I submitted in the previous hearing proposed orders a proposal and an order for signature. When you made an order that didn't adopt all of those, Mr. Ball quickly piped up and said he'd prepare the presentation, to which this court agreed, denying me the ability to prepare my own presentation. And we wouldn't be having this conversation because I follow orders. So it would be the old parenting plan struck with the pieces you ordered and inserted the parts that you had ordered to be changed.
And you're referencing it looks like an April 19th submission of your proposed parenting plan, correct?
That sounds reasonable, yes.
Okay. So in your proposed parenting plan from April 19th, under section 14, comparing those two, the current proposed by Mr. Ball and yours, is there some overlap, or is there some areas in which they are similar, or are they starkly?
There probably is overlap. I did not read them letter for letter. I just noticed that his was very boilerplate. And the last one caught my attention, which is the sports and extracurricular activities, which supersedes parenting time. And that's exactly what Heidi has used in the past and been told that is not to happen, even though it's still happening.
Okay. All right. Thank you, Mr. Ellis. Mr. Ball?
Thank you, Your Honor. So under section 3, the 191 factors, I saw that was reserved on the temporary orders, the previous temporary parenting plans, and the court didn't specifically order that. So I included that. I was just going to run that by the court today because there is supervised parenting time and there is reunification counseling. So that's why I included that. And then there is another issue with section 4 that Mr. Ellis didn't mention. And we talked about this. It has to do with the professional supervision. That's under supervised contact. I don't think that there was some discussion at the hearing whether or not the parties agreed to that, but it wasn't specifically ordered by the court, and Mr. Ellis is not agreeing to that provision. And well, that would need to be, we're just addressing that to the court. You know, it's completely discretionary on Mr. Ellis's part. He brings up the fact that it's expensive and and he already has a high maintenance order in this case, and well, he also feels that it's going to be used to further, curtail or affect his parenting time or try to reduce his parenting time in the future. But that's not really the spirit of it. But so that's the other section Mr. Ellis didn't mention. On the holiday schedule, we were trying to get an agreement on the holiday schedule. Apparently, Mr. Ellis doesn't agree to that. What he brings up, the good point, is that he can't have us, the older children would need to be supervised or something like that. And there's not a supervisor available on holidays because they're using a friend. And so that I would say, I guess he doesn't agree to that. So that I guess should be stricken. Otherwise, I would say that it would apply to the younger children, and the older children could opt out. It would be, but that wasn't ordered by the court. And also under section 12, this is agreed change. I don't think Mr. Ellis touched on this, but transportation arrangements under other location. It should say the location of the father's parenting time, striking out the words supervised. Because I guess sometimes he has parenting time, or the location where he's visiting with it, having parenting time with the children is not at his home. As far as the other sections, I just this is what I use in my office. I didn't mean to exclude anything or include anything that had most of the time, it's just what the court will order. Other factors, I don't have the information about what Mr. Ellis is talking about scheduling extracurricular activities, but but I think what makes sense if the court's going to entertain this is that it should be extracurricular activities that are through the school, through the children's school, as opposed to I don't know, like piano lessons or dance lessons or something like that. So those would be the limiting things I would just from my perspective. But I think I was looking through his real quick, and I don't have an objection to those necessarily. I don't know which. I guess if he wanted to pull his page or something like that and put it in there of his.
On his section 14.
Yeah, I don't know what. So sorry to screw that up, but so that's what I have on that's. I think those are all the objections that Mr. Ellis brought to my attention.
Your
Okay.
Honor.
So one moment, just a follow-up question for Mr. Ball. On Mr. Ellis's section 14 of his May or April 19th, you're comfortable just pulling those 1 through 16 and placing those into the section 14 of your proposed? Is that what did I hear you correctly?
Yeah, I mean, I don't really see I don't know where they came from, but so I looked at them and they seem okay. I don't know if there's an issue with the extracurricular activities or not.
Okay. Mr. Ellis, would you be comfortable if we took your section 14 and placed it in the proposed order of Mr. Ball?
That would certainly be a start. I have no reason to change section 14. Its origination was the petitioner's original attorney, Tanya Green. She's the one that created that verbiage, not I. It's been copied from order to order. Okay. And back to the section 4 and me not agreeing to it, I did agree in discussion at our hearing. I would love for the court to order that I have a fixed number, not an open-ended number, which is in, I believe is how it's worded in Mr. Ball's proposal. I would love to have the court order, say, I don't know, 4, whatever you think is appropriate. Amy's on the line. She can help determine what that is. I had a wonderful conversation with Beth Bellows after the last hearing. She is the proposed supervisor, professional supervisor. If I knew that there was an end to it and the end result would be the removal, or I would hate to say continuance, but the removal of the non-professional supervision for the 2 oldest, I absolutely would entertain that, because I want anything that will get me back time with my kids that the court won't view as repeated hearings or changes and modifications. As long as it's court ordered to come back up, which I feel like all the others were, then yes, please, let's do it any way that we can to show that this is in the best interest of the children.
All right. Thank you, Mr. Ellis. All right. So starting off with the 191 factors in section 3, there is included a history of domestic violence and also a lack of emotional ties that specifically says that there's few or no emotional ties with the child listed in paragraph 2 or section 2. So Mr. Ellis points out that he's completed the domestic violence course successfully. He points out to the course curator or the course presenter indicating that he doesn't have domestic violence. I think the key difference here is that there's a history of domestic violence, and domestic violence is defined rather broadly under that 7.105. So I'm going to include that in there as a history. As far as a lack of emotional ties, I think that's Mr. Ellis points out that it's unidirectional in that he has lots of love and concern for his children, and that there's maybe not a reciprocity returning towards him. I think the fact that there's a supervised visitation that the court did order, and there's reunification counseling order, that highlights the fact that there are some strained emotional ties. So I'm going to leave that section or that portion in the proposed order. Under section number 4, the limitations as far as the supervised contact, Mr. Ellis is concerned related to an end time for that provision, and he wants to have a set number. Determining when a child is or a parent or the combination of the two is ready to move on from a certain set of conditions is difficult at best to predict. Yeah, human nature is difficult to gauge, and where a person is and how quickly they'll get to that stage. So I understand that the need and the want to have a set date for it to end. I'm certainly not opposed to a review to address that issue, but I think it'd be not wise to set a hard and fast date as like this is when this provision is going to end. Certainly a review date could be set or could be noted up for review. I'm not averse to that. So so that's number 4. I'm gonna leave that in as presented. Then looking at section 14, I'm fine with the wholesale replacement of the proposals, the paragraphs proposed by Mr. Ball, and replace them with the proposals propounded by Mr. Ellis in the April 19th order, or his proposed order. Under the holiday schedule, there's a lot of information in parenting plans that in a hearing isn't necessarily addressed bit by bit. If we did, we would have 7-hour dockets. So there's some kind of a shorthand that is generally used. And so since the court did not order the holiday schedule, I'm striking the entire thing, and the parties will be on their own to try to figure that out. Under section 12, I did make that correction, removing the word supervised under lines between 6 and 7. So the exchange location would be at the father's parenting time. So related to that, I'll ask Mr. Ball if you would be in a position to amend your proposed order to include the section 14, including Mr. Ellis's proposals therein instead of yours, striking the word supervised on page 5 and striking the holiday schedules, and then submit that to the court and with a CC to Ms. Turnbull and to Mr. Ellis.
Except looking at section 14, it does include the a provision about reunification counseling. And so I wanted the judge to peek at that and see if that was sufficient enough language there. But I would keep that in there and then strike the rest of it, include the previous or the one from father's proposed orders.
I think that's fine, Mr. Ellis. Any comment on that?
I'm sorry, reunification counsel is in section 14, your section 14?
Under
Oh,
Mr. Ball's.
at the very top?
Yep, at the very top, right.
I thought it was also under section 4. Maybe
I think
not.
it's a little bit different if it wasn't 4, because I didn't remember Ms. Brandhorst's name being included there.
So that's fine to put that down in section 14 as a header to whatever we're substituting back in, the old stuff.
So we'd keep reunification counseling, keep that paragraph in, and then just take wholesale your proposals from your 14 and include them below that.
And Your Honor, when you said that you're keeping section 4, opposing counsel had agreed via email to remove the unsupervised children, because the way he wrote it, section 4 states that I will now go from unsupervised with my children to all supervised with my children.
I thought it says the parenting time regarding Joseph and Carly.
So in the parenting, the parties will use a non-professional supervisor, agreed third party, but then the very next sentence says, father will use a professional supervisor, Beth Fellows, for his parenting time with all children.
Well, maybe the language says father may use a professional supervisor. Maybe Mr. Ellis's copy. I think that was the original language, but we changed that.
Well, the only one that I have by email says will.
Yeah, so yeah, the parenting plan that I'm looking at says supervised contact, parenting time with Joseph and Carly shall be supervised. The parties will use a non-professional supervisor and agreed third party. Father may use a professional supervisor for his parenting time with all the children to be able to provide feedback about parenting, interaction, relationship from that supervisor.
Okay, so Your Honor, that's hard to follow when you read it. I'm now understanding that you are marking up a copy of a document that I have no copy of. So I don't know exactly what we've.
Well, I'm looking at the same document that was provided from Mr. Ball, so you should have a copy of that.
Yeah, but that's not the one he sent me.
So what does your copy read?
My copy is, let's see what it's dated here. Mine doesn't have a date on it. It's 9 of 8 pages. And in that section, it says, father will use a non-professional supervisor, agreed third party. Father will also use a professional supervisor, Beth Fellows, for his parenting time with all children to be able to provide feedback about his parenting.
All right, so it looks like it may be a different version. So what we need to do is make sure that it reads that the parties are going to use a non-professional supervisor and then uses the permissive language of using a professional supervisor, basically for feedback. So we're going to need the order itself needs to be revised with the replacement of section 14 with that reunification included. So we're going to have to come back and look at this with fresh eyes. So let's come back next week and just parties can exchange those copies, and then we'll be back here and we can take it first on the docket and get it done quickly so as to not take additional time from your schedules.
And did you, I know you talked about a review from, say, Beth Fellows. Did you actually modify section 4 to include that, or how is it?
Yeah, good question. I didn't set a specific date. I was certainly open to that possibility, and as also open to the possibility of having one of the parties, yourself included, noting it up with notice to the other side to review that specific issue. So it was kind of flexible in my approach.
My fear is that last hearing, I felt like it was held against me as the number of frequent changes to parenting plan. Is that going to be held against me?
So we're talking about a potential review. So let's kind of focus our attention on that. So if you want to propose a date for a review, I'd be happy to include that within the order.
Okay, we'll bring that back next week then. And I would also like you to clarify once again, in the last hearing, I asked for clarification. When did this take effect? And you said, immediately, I've already ordered it. And we have a case where I have an email from Heidi that refuses to begin the reunification counseling until there is a signed court order to do so. How do we tell the opposing party that it was already ordered back on May 8th or whatever it was, and that it is not voluntary, it must be followed?
Mr. Ball?
Your Honor, my client reached out to the counselor the day of the hearing, at our last hearing, and she just conveyed the message to Mr. Ellis that the supervisor wanted the order. So she's not refusing to engage in reunification counseling. She hasn't done that, but that's what she told Mr. Ellis, is that when you sign order.
All right, thanks. So the order is in effect. It is in effect as of May 8th. It sounds like the counselor may have some other requirements. So all parties are expected to follow the court's oral order, and then we'll be back next week to finalize the order with the revisions. I think we spent more than adequate time on the issues today. Ms. Turnbull, do you have any comments?
Not at this time, thank you.
Okay, we'll come back next week, assuming all parties are available. Mr. Ellis, Mr. Ball, both available next week on the 12th.
Yes, Your Honor.
Yeah, self-available. And thank you for your flexibility. I know it was a lot of time.
Okay, great. We'll see everybody then. Thanks.
Thank you.
Okay. All right. So Ms. Bailey Keegan is present, and Stephen Trotter, just for sake of clarity, Stephen Trotter, if you're on the Zoom call, please unmute and state your name. Stephen Trotter. Okay. No response, and Ms. Keegan indicates that he's not planning on being here
He
today.
did actually say that he planned on being here. I don't know when.
Oh. Okay.
I don't know. Do you want to maybe come back to us, or is there something I can?
Yeah,
address?
maybe we could do that. And if sometimes it happens with me that I get going on calling next case and next case and next case, and sometimes I forget those people that I said, hey, I'll call you fairly soon.
Yeah.
So feel free to raise a hand when I come to the conclusion of a case, and let's review that. Maybe we can review it in. We're at 9:45, just maybe sometime before 10 o'clock. So if you just raise your hand and just remind me.
Okay, thank you.
That'd be great. Thanks.
If we could start with Vaughn and Kiyoshi. I'm not sure if the parties are ready to enter a final parenting plan or not. We didn't receive a copy of one, so I'm not sure if we may just set over today.
Tell me the case again.
Vaughn and Kiyoshi.
Alexandria Vaughn, are you on the line today?
Yes.
Great, welcome. And Zachary Kiyoshi, are you on the line?
Yes, Your Honor.
And Ms. Fellows, I see, is also joining us today.
Yes, Your Honor.
Okay, so today I believe it was noted up for, it looked like there's a review of some proposed child support orders that Ms. Looney had submitted. And Ms. Looney, just remind me with this, did the state file a motion for the child support orders?
Your Honor, we were coming back today. My understanding was that the parties were potentially going to be entering an agreed final parenting plan today. So we did provide child support orders if that was going to be entered today. If it's not, We would just be asking to set our child support order over to the date that they would be planning to enter a final parenting plan.
Gotcha. Thank you. All right, Ms. Vaughn, what's the status of any potential agreed orders?
So I did submit one to go back to you, and I do have it listed as a temporary order, but I don't have any opposal to it being adopted as a final. Him and my father, well, I can't even talk right now. His father and I are in agreement on it, and Beth also signed it.
Okay, Mr. K.
And Your Honor, the state did not see a copy of that, so we are not aware as to what the final parenting plan looked like for purposes of child support.
Okay. And Mr. Kayoshi, did you get a copy of the proposed parenting plan?
Yes, I did, Your Honor.
Okay.
We did. We talked about it.
And it looks like you both signed off on it, correct?
Yes.
All right. All right. That's great. And then, so Ms. Looney needs to get a copy of that. Ms. Vaughn, are you in a position to forward a copy of that document to her?
Yeah, I can drop it off later today.
Okay, that'd be fantastic. And then, Ms. Vaughn, so let me just clarify here. So this will be the basis of my question. It's Looney, for purposes of child support, it looks like the primary custodial parent is agreed as to Ms. Vaughn.
Okay.
With, let's see.
Your Honor, I believe we could enter our order today if the parties have had a chance to review it. And we did leave some sections blank if they had requests of Your Honor to make changes to our proposed order.
Okay. All right, so I'm fine signing off on the parenting plan, and then let me just double check with each Ms. Vaughn and Mr. Kayoshi. Did you receive copies of the state's proposed child support worksheet and also order?
I did not.
Okay, Mr. Kayoshi.
I did receive that in the mail. Yes.
Okay.
Just looking to see, Your Honor, when we sent that out.
Okay. And it would be two separate documents, the worksheets and also a proposed child support order.
Yes. Looks like we sent that out on May 14th, Your Honor.
Okay, and let's just double check here. I've got an address for Ms. Vaughn on 9th Avenue.
No, that's not my address.
Okay.
And then if she can update her address, so we can make sure she gets a copy of that. If we can get that quickly and get that out to her, we could ask for us over 2 weeks, and that way we can make sure everyone has seen everything we've proposed and come back to enter that order.
Okay. So, Ms. Vaughn, when you forward the parenting plan over to Ms. Looney, could you also include an address where she could provide you a copy of the proposed child support orders?
Yeah.
Okay. And that sounds great. And do Ms. Vaughn, do you have Ms. Looney's email address?
Yes.
Okay. And so if we were to set it over 2 weeks, that falls on a holiday, so it'd be on the 26th of June.
That would be fine for the state.
Okay. Is there any opposition from anybody if I were to sign off on the parenting plan as presented?
Nope.
Okay. Mr. Kayoshi, are you good with that?
If we're gonna hold off on the child support, can we wait until then for you to sign off on it?
You can. Is there any reason why we should?
No, I don't know. I mean, we've talked about it and I've looked it over, but I just want to get everything signed all at once. I don't want to be signing and then coming back to figure other things out.
Okay. Well, I think since the parties have expressed to me that they're in agreement with the parenting plan, it's been reviewed by each and both have signed off on it. I'm going to sign off on it today. The parenting, so that'll be in effect and is ordered now. The worksheets and the child support worksheets and the child support order, all parties have a chance to look at that and comment on it. And so we'll be back on June 26th, just confirming everybody's available on Wednesday, June 26th at 9 a.m.
Yes.
Available.
Okay.
And then I had one more question, Your Honor.
Okay, go ahead.
So this is all agreed on. If once this is set in motion, when is the next review or revision? Because we had talked about this before making this child care plan. Is this set for, how long is this set for? Or can we come back and relook at this before he starts kindergarten? Because we discussed that.
So the child's three years old right now, correct?
Yes. Yeah. Good. Yeah.
So if this is an agreed final order, then the parties would need to bring a motion for adequate cause. Basically, a motion for adequate cause is saying, hey, there's been a substantial change in the circumstances of the child or the parent with whom the child lives, and we need to modify that. And if the court grants that there's enough there, then the court could take a look at a petition to modify the parenting plan. If this is a temporary order, then things are unresolved. Then the case would be set for a trial. And then once the trial is heard, then a final order would be entered. And then the same rules would apply as far as a motion for adequate cause and a petition to modify the parenting plan.
Okay, so
yeah.
If both of us agree to review this in 2 years, then that's on us to do, correct?
Yeah. I think that's a fair assessment. So okay. All right. Any other questions related to that or others? Mr. Kayoshi, any additional questions?
No, Your Honor. Thank you.
Okay. Ms. Vaughn, do you have any questions?
Nope, just want to clarify that we're entering it as a final order instead of a temporary then?
That's my, well, the party signed off on the box is marked as temporary order. That's how it's marked. So if that's the party's intent, then I'd leave it as is.
I'm cool either way.
Okay, Mr. Kayoshi.
Good, Your Honor.
Okay.
Your Honor, if they're not entering a final order, then we would just strike our hearing. We were asking to do a final order. We thought the case was being finalized and then we would not be keeping it open in the courts. So at this point, the state would ask that the temporary order that's currently in place remain, and we would not be asking for a final order.
Meaning the temporary child support.
Yes, Your Honor.
Okay. So let me touch base with Ms. Vaughn, Mr. Kayoshi related to that. So the state's saying, okay, if this is a temporary parenting plan, then they're withdrawing their request for a final child support order, and then the parties would be guided by the temporary child support order.
I'm okay with putting it as a final so that we can also take care of the child support as a final as well. That way we can move forward with our actual whole divorce case.
Okay, so meaning the parenting plan would be final, and then we could come back on the 26th, review the child support final order, and then just have everything completed at that time.
Yes.
Okay, Mr. Kayoshi.
Yeah, I'm just trying to finalize everything as well. So.
Okay, so if I understand the parties correctly, on the parenting plan, it says this is a temporary order. If I understand you correctly, you're wanting me to white that out and make it a final order, and then we can finalize the child support on the 26th.
Yes.
Yes, I do. I mean, if we are going to make this the final, I would like to go over 14 and just take everything out of that. And she can talk her side as well. But if you go to section 14.
Okay.
Go ahead, Your Honor. Sorry.
Yeah. So I was presented with an order that was signed and agreed by both parties. What I'm hearing is that if we change it to a final order, that there's not agreement with the proposed order because section 14 is therein.
Right. It's just because, I mean, I understand that we can come back in 2 years to review this. Mm-hmm. And I don't know what could happen in 2 years. So I don't know if I want to make this a final and not be able to change anything after the fact.
Okay.
After it's set in motion.
All right. So
we've talked about this, me and her, but go ahead, Your Honor.
So I'm getting a bit of a conflicting direction that you're wanting to go. On the one hand, you're telling me that you want to you want to sign off on the final parenting plan as a final order, but then you're saying, wait, I don't want to do that. I want to move section 14.
Yes, Your Honor. So can we come back on the date that Miss Looney, or that we could set the child support for review for me to talk to Miss Alexandria and then have everything set in stone before with the child support, and we could all just sign off on everything that day?
Ms. Vaughn?
I am okay with that. I think the only thing his dad is referring to is the alcohol stipulation, no intoxicants. He wanted to review that before our kid starts kindergarten, so 2 years from now. That's the modification he's referring to specifically. And I still think that even if we did it next month, it's still going to include that for now until we do that modification in 2 years.
Okay. All right, Ms. Looney, it sounds like there's some potential for there to be a final parenting plan on the 26th. Would you be willing to come back on the 26th and address the potential of final child support orders?
Yes, Your Honor. We would ask to keep that date.
Okay. Well, let's do that. The parties, it sounds like you could talk a little bit more. You know, you've already agreed to the vast majority of the parenting plan, so good for you, good for your child. And then you can talk a little bit more about section 14, and then let's come back on the 26th of June at 9 a.m. to address both the final parenting plan and also potentially the final child support order.
And Your Honor, I would just remind the parties that if they make a new agreement and change the order that they're planning to enter, that we get a copy of the new one.
Yeah, that's important. Yeah, if anytime that there's a new proposed order out there, please forward that to all parties involved. That'd be much appreciated. All right. Thanks everybody for your input. We'll plan on coming back on the 26th of June, Wednesday at 9 a.m. to potentially resolve the case.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor. We can go next to what I believe is number 12 on the docket. I'm not sure if I'm pronouncing the last name right, but Ranji and Ellenbolt.
Thanks. All right. So Brittany Ranji and Brandon Ellenbot, if you're here in the courtroom, come up and take a seat. Come on up. And then if you're on the line, just go ahead and unmute and state your name, please.
Brandon Ellenbolt.
Okay, great. So we have Mr. Ellenbolt on the line. I can see and hear him just fine. And then do you pronounce your last name Ranji?
Yes.
Ranji. Okay, Ms. Ranji is present in the courtroom and Ms. Looney is present. We're here for the state's motion related to child support. Well, it looks like both parties were served copies of those proposed orders and motions. I'll just confirm that with Ms. Ranji. Did you receive a copy of the state's documents?
Yes, I did.
Okay. And Mr. Ellenbot, did you receive a copy of the state's
Yes, sir.
documents?
Yes, sir.
Okay. All right. Very good. So I'll hear first from Ms. Looney, and then we'll hear from each of the parties. Ms. Looney.
Thank you, Your Honor. So the state's motion today for temporary child support order. We have, excuse me, we have used Mr. Ellenbolt's 2023 employment security data income for all 4 quarters to calculate his income at a net monthly income of $6,773. Ms. Ranji is a current TANF recipient, so we have imputed her income at the current minimum wage of 32 hours a week, which gives her a net monthly income of $2,035. There are 3 children, so the resulting transfer payment for Mr. Ellenbolt would be $1,862 per month, which comes out to roughly $620 per child. We are asking that start date be October of 2023. That is when the children began receiving TANF benefits.
Okay. All right. Thank you. All right, Ms. Ranji, do you have any comments related to the state's request for child support? Okay. All right. Thank you. Mr. Ellenbot?
Yes, I do actually. So it looked like in the order, they went off a 76-23 parenting schedule, I think it was, and I had submitted a declaration to the court and also to the state that that's not the case. It's a 50-50 custody. I submitted a drop-off and pickup sheet for our youngest, which would kind of give a basis of what the parenting schedule actually is currently.
Okay. And Ms. Looney, did you receive Mr. Ellenbolt's declaration related to that?
I did, Your Honor. The pickup and drop-off sheet was a little difficult to read, but regardless of whether there's a 50-50, at this point, the TANF being in place for the children, you cannot do a residential credit under RCW 2619-075 when the children are receiving TANF. So we would need to be requesting that the full transfer payment be paid. Ms. Ranji has abrogated her right to child support to the state of Washington while she's on TANF. So we would not be looking at requesting a deviation based on a residential schedule.
So that statute 2619-075, is it a strict prohibition?
Yes, Your Honor. It's subsection D. It says that a residential credit cannot be applied if the children are receiving TANF assistance.
Just going to pull that up under section B as in Bravo.
D as in dog, Your Honor.
D as in dog. Thank you. So it says the court may deviate from the standard calculation if the child spends a significant amount of time with the parent who is obligated to make support for the transfer payment, meaning Mr. Ellenbolt in this case. Goes on to say the court may not deviate on that basis if the deviation will result in insufficient funds in the household receiving the support to meet the basic needs of the child, or if the child is receiving temporary assistance for needy families. So that's the indication that you had mentioned, Ms. Laney. Okay, thank you. Yeah, 2619-075, D as in Delta. All right, anything else, Ms. Looney? Okay,
Your Honor, Mr. Ellenbolt had also provided information regarding direct payments that he had made, wanting to have I believe he was asking for a different start date. Your Honor, we're asking that not be considered to be added to the order today. he does have the option to give information to the Department of Child Support so that he can request that they credit his account. But at this time, Your Honor, we'd be asking the order be entered as presented.
Okay. All right. Thank you. All right. So, Mr. Ellenbolt, as far as you mentioned, the kind of the 50-50 parenting arrangement, and then Ms. Looney addressed that particular statute that says if a child is receiving or a parent is receiving TANF, then the residential credit, which would normally be available, is not available. And then Ms. Looney just lifted up those final items of where you detailed the different months and the dollar amounts that you provided amounts of support.
Correct.
That she's indicated that the Division of Child Support would entertain potential credit based on funds provided in the past. So I'll hear from you.
Okay, I guess my question to all of that would be, I had talked to somebody from the Division of Child Support, and they had said that it's like a first come first served basis type of deal for the TANF. But with me and my job, I wouldn't have qualified for it. So with our parenting being 50-50, being exactly the same, she doesn't have the kids any more than I do. I don't understand why she would be entitled to it and I wouldn't be entitled to it.
Well, the one item is that at least it seems and is borne out by the statute is that you make a lot more money than she does, and then the state is stepping in to provide some financial support to support her and the children.
Okay. And I guess my next question would be, so I guess the state's not going to recognize any of the money that I've given her or any of the time parenting or any of the, I guess, medical that I pay for. Pretty much I pay for everything is what I'm trying to say. Currently.
Yeah, I think Ms. Looney addressed that. She had indicated that the Division of Child Support is open to giving credit for past payments while the child or children have been on or have been receiving TANF. That a credit could be, if warranted, could be granted. Because I went through and I calculated all the submissions that you supplied with the different screenshots. And I came up with a total over 18 months of $12,077.50 for an average of $670.97 a month. So I calculated that based on that information that you had provided, the transfer screenshots. So that sounds like there's potential for that to be potentially credited.
And Your Honor, I do want to clarify, he did provide documentation of months prior to where we're asking for the support order to begin.
Right.
So those wouldn't be counted by DCS.
I guess the reason I entered all of those is because me and Bernie have gone through this exact scenario before. So I dated it back all the way past when we had went through it the last time as well.
Sure. Ms. Ranji, you had a question for you.
The judge, he did not actually keep to his promise of paying child support. And in order for you to be paying what you have been paying as of recently, I had to give you half of my tax return.
That's not true.
100% is true.
Okay. All right. Thank you, Ms. Ranji. All right. So the motion is brought by the state by virtue of the mother receiving TANF, and doesn't sound like there's much dispute, at least from Mr. Ellenbolt's perspective, as far as what his net income is that was used. The employment security data was used to come up with those totals. And for the mother, she was imputed at full-time minimum wage for 32 hours a week to come up with her net income. So the concern raised by Mr. Ellenbolt is that, hey, look, we've got a 50-50 time split with the kids here. There should be a reduction of the child support because the kids are with him 50% of the time. The legislature of Washington says, yeah, that may be the case, but not allowed to deviate based on the residential schedule. So I think the state's motion is well taken. I'll set the father's net income at $6,773 and the mother's net income at $2,035. That results in a child support transfer payment of roughly $1,862 per month based on a family of 3 children. As far as the start date, you look at the start date back to October and to now, that's 8 months, and that's a significant hit when you're talking $1,800 a month. Ms. Looney, when did you file your motion for child support?
Your Honor, we filed it in April or May, but the reason we're requesting the back start date is because that's when the children began receiving TANF, and the mother does subrogate her right to support while being on TANF to the state. So those funds would be going to reimburse the state at this point.
Gotcha. Okay, thank you. All right, so I'll have the start date start May 1 of 2024. So start date will be May 1, 2024. And then I have, I believe, orders that were submitted by Ms. Looney. Did you submit orders, Ms. Looney, on this case?
We did send those over to your honor to the court on the 20th of May.
Got them. All right, so I'll ask Ms. Ranji, did you receive a copy of the state's proposed child support worksheets?
Yes, I did.
Okay, Mr. Ellenbolt, did you receive a copy of the state's proposed child support worksheet and order?
Yes, I believe I did.
Okay, so I don't think there's been any changes. The same numbers that are being used and have been discussed here today. As far as the start date, I'm going to change that in paragraph 11. Monthly support amount must be starting. I'm going to put May 2024.
And your honor, I just would want to clarify for Mr. Ellenbolt that at this point, that would mean he does not have any potential for credit for prior months because they're not being included in the order.
But current months I do though.
Yeah, so it could, yeah, right. Okay, that makes sense. And then the proportional share for uninsured, medical, and others. So go ahead and that order seems to be in order. So I'm going to go ahead and sign the child support order. And then the worksheet also bears out the same numbers. Okay. So I've signed off on both of those orders, making the one adjustment in the actual child support order as far as the start date, meaning May 1 of 2024. So it doesn't encompass those back child support orders that we had talked about getting credit for that because the order doesn't encompass that time period. So at this point, any questions or final items from you, Ms. Looney?
No, your honor.
Ms. Ranji, any final items? Okay, Mr. Ellenbolt, any final items?
Yeah, I guess so. Should I stop paying her directly then?
So the child support, and Ms. Looney, I don't have the orders in front of me, but is the division of child support on the receiving end and then dispersing the funds to Ms. Ranji?
Yes, your honor, he will need to pay through the registry going forward.
Perfect.
All right, so the payment would be through the registry, and so they'll have a third party recording everything.
Yes, and the information to contact them is on the order, so he does have a copy of that.
Okay.
All right, very good. If there's no further questions, thanks everybody. Appreciate your help, and that'll resolve the case for today. All right, thanks.
Thanks.
I'll ask if
Thank you, your honor.
Ryan Denlocker is on the line or present. Ryan Denlocker, if you're here, make sure you unmute and state your name. Ryan Denlocker. I'm just going to take a look at the participants on the Zoom call, see if there's anybody with a similar name. There's nobody with a Ryan, and there's nobody with a DEN. So it looks like he's not present. And then I'll ask if Heather Lucor, if you're present. Heather Lucor, are you present?
Yes, I am.
Okay, Ms. Lucor is present. All right, so this is your motion, Ms. Lucor, to modify the parenting plan and appoint a guardian ad litem. As far as service of your motions and documents upon Mr. Denlocker, I see that you used an email address to serve him copies of those documents. The question I have for you, is there an order or an agreement, an agreed order that allows service via email?
Yes, there was in the past, because after he had moved from his mother's house, he had wanted me to serve him through email instead of in person. And I don't even have his new current address to be able to serve him in person. And I also serve him weekly with my UAs through email.
Okay, so you mentioned that there was a prior agreed order or an order. Can you give me a time frame of when that order was entered? Because I was looking at it, I couldn't find one.
So I don't know if there was an actual order. I think it was in our paperwork. It was like an option when he had filed paperwork where you would mark that you agreed to be served by email. Yeah, I believe that's where it was at.
Approximate time frame?
So that would have, I believe it would have been in the paperwork he filed either the end of November or it was possibly the one that we had went into. I think it was the end of December or maybe beginning of January. But when he originally, I just don't remember if it was when he originally filed in November that he had marked that or if it was a later date. because he moved out of his mom's house the end of December. I know that. And it was after that point that I didn't have a current address for him. But he had like marked that I could serve him by email. And then when he came to pick Emma up a couple weeks ago, I had confirmed in person that he had received the email because he wasn't responding back to me. And he said, yes, I received it. I haven't had time to really look at it yet because I have to do it on a computer. And I asked him if he would like a copy, a paper copy of it. And he said yes. So I also gave him a paper copy of everything. But I know I'm not supposed to serve him myself in person. So I just made sure that he had confirmed that he received the email as far as proof of service. And then I did also give him the copy, like I said, of everything in paper form.
Okay, thank you, Ms. Lucor. So the clerk helpfully pointed out in his response to the petition filed on January 19, 2024, on the last page, he declares under penalty that the foregoing was true, and he's attached that, he signed it, and then he says, I agree to accept legal papers for this case at a particular email address, and then I'll double check to see, make sure that's the same. It is. So it looks like email, the service was proper. And so there's a parenting plan. And have you heard from Mr. Denlock or Ms. Lucor?
Not today. I looked on to see if he was present, and I saw that he wasn't on there. So I sent him a message asking if he was going to be logging on to the Zoom call, and I haven't heard anything back from him. So I haven't spoke to him since last Saturday when he picked Emmeline up.
Any indication that he was planning to be here or not planning to be here?
No, not specifically. The only thing he said to me about it at all was just that he felt like my request was unrealistic. But that was weeks ago that he said that, so.
Okay, all right. Give me just one moment. First item is your motion to appoint a guardian ad litem. Based on the service via email, I'll grant that order. We take appoint guardians ad litem on a rotating basis. And so we take the next 3 individuals who are on the list, and each party can strike an individual that's on that 3 list. And then we end up with 1, or if there's no strikes, then we end up with the person who's on the top. So I'm going to ask our clerk to tell me read the names into the record of the 3 individuals who are next on that list.
Amy Turnbull, Beth Fellows, Heather Call.
Any of those 3 individuals, Ms. Lucor, that you would like to strike?
The first one, I would like to, sorry.
So if you strike the first one, then the next person would be Beth Fellows.
Yes.
Okay, so I'll appoint Beth Fellows as guardian ad litem. And so I've signed off on your proposed order. The next issue is the parenting plan that was submitted for review and discussion today. I'm a little more hesitant on that because as a general rule, service needs to be done either in person or through mail or some of the more traditional ways. And then there needs to be an agreement for for serving via email, which he specifically said, I agreed to service. And then there's an affidavit of mailing that you use that same email address that he agreed to receive service. And so that was done on May 17th, giving him notice of today's hearing about your motion, the proposed parenting plan, the guardian ad litem, and the like. I'm a little hesitant to sign off on that, but he was given notice, so I'll sign off on that.
May I ask a question really quick?
Sure.
So I did fill out the paperwork as far as the fee waiver for the guardian ad litem. I was told to wait to turn that in until it was decided. So would I just, now that you did appoint a guardian ad litem, now would I go in and just turn in that paperwork?
On the guardian ad litem order, I said it was going to be what we call a county pay case. In other words, the county pays the guardian ad litem for their services.
Oh, okay. Okay, so I won't need to turn that in then.
No,
okay.
I don't think so. No.
Okay.
All right, so I've signed off on the parenting plan. You can get a copy of that order from the clerk's office in a couple days.
Okay, and that when does that go into effect?
I signed it at effective today.
Oh, okay. So I guess as far as I had requested rotating weeks. So I guess if it starts today, then would my time with her start on Friday then? Is that, I think that was how I had stated it. Like, I guess I just am not sure, like, as far as when it starts, would my week starting on Friday, or would it be like?
Yeah, I don't think you
Sorry.
specified in the order, you just indicated it'd be alternating weeks, starting on Fridays. So if who's the child with currently?
Ryan.
Okay. So then if it's with him now, then that would be kind of an understood that he has custody now, and then the alternating week would start on the Friday as indicated by the order.
Okay. And then I did have one more question. So I had mentioned that he's in the middle of a DUI case in Clark County, and he is scheduled to have trial for it's his third DUI. It's scheduled on June 13th. I had put the 16th, but I guess it's the 13th. I'm mainly just worried if he does get convicted of that and he's sentenced to jail, as far as that changing things. So I didn't know if we could maybe set up a review, or if I would need to file for that, or how that works. Just like if he does end up getting convicted of that and he is sentenced to jail, then how do I go about that? Or are we able just to set up a review like right after his trial to review that?
Is your concern that he'd be incarcerated and unable to care for the child?
Yes.
So if he's unable to care for the child, then obviously that you would be the parent charged with caring for the child while he's incapacitated.
Okay.
So I don't
just
think
wanted
there
to
needs
make
to be a
sure that.
separate order. Yeah.
Okay. All right. Thank
Okay.
you.
All right, very good. That'll conclude the matter for today. Thank you.
Thank you.
Tatum, are you on the line or present in the courtroom? So we're gonna.
Yes, I'm on the line.
Okay, thank you, Ms. Tatum. And then Robert Tatum, are you, if you're on the line, unmute and state your name or come on forward.
Yes, I am.
Okay, very good. All right, so both parties are present and Ms. Looney is present. This is Mr. Tatum's motion for temporary order that he filed back in February of this year. And it looks like that the primary custodianship of the child, Gage, Mr. Tatum agrees that it would be Ms. Tatum. Is that accurate, Mr. Tatum?
Yes.
Okay, and then sole decision making, you're comfortable for mother having sole decision making related to health and education and also non-emergency healthcare decisions?
For the moment, yeah.
Okay, and then as far as your parenting time, you're requesting Saturday 7 a.m. to Sunday at 9 p.m. on every weekend. Is that correct?
For now, yeah.
Okay, and there's also the existence of the restraining order that's still in place.
Right.
All right. Ms. Tatum, do you have input related to Mr. Tatum's motion related to the parenting plan?
We keep coming to court, yet I have not been served with any proof of his going to treatment or mental health.
Okay. So it looks like just recently, Mr. Tatum filed some documentation that at, I believe it's CORE, if I'm not mistaken. He's in, let's see. Yeah, CORE Health. It's a letter dated May 27th, 2024. It indicates that Mr. Tatum on May 27th had a one-on-one with a counselor, and it was attended group on April 22nd, May 20th, and May 21st. And I don't have any records relating to mental health evaluation or any treatment.
Your Honor. Also, I filled out an ROI for Dream Tatum. She can check my compliance report anytime she wants. All she has to make a phone call. And like I said, that is a compliance report. I'm in full compliance right now. So I'd just like you to visit and go from there this time.
One point, if I may ask you, Mr. Tatum, you had indicated, I think previously, that you had started SUD or substance use disorder treatment back on February 11th. Is that accurate?
Yes.
Do you have any documentation that you've filed that says that shows that you started or engaged in treatment from then until the middle of April?
No, that paper, I thought he was going to write the dates on that. He was not feeling well at the time. He just got over what's called vertigo. He was having some vertigo issues he just came back to work, but he still had vertigo as he tried meds.
Okay.
And I asked him to put the dates on there, but I don't know. I thought he did at the time. Like I said, I did sign the ROI for her. All she has to do is call and check anytime she wants. I'm in full compliance right now, and I'd like to give a visitation.
Okay. So one thing, that I think was important in the case was to show a track record, if you will, of continuing involvement. It sounds like you're engaged with CORE, but it shows a very limited time frame. It shows a group meeting back in April, and then 3 meetings here just recently at the end of May. But then I don't have anything also for the mental health, either the evaluation or any treatment. So those records would be really important to establish, a track record that you're doing well, you're making some improvements, and things are going better.
Okay.
So we've kind of been looking at this since the end of February, and I'm not sure what each party's intentions are at this point. I'll ask Ms. Tatum, related to Mr. Tatum's motion from end of February. Tell me what your position is currently on the case.
I feel that he has not done very much to prove that he has been taking UAs, going to group, and also mental health. And it was that he was going to have paid for supervised visits, as I understood it. And I have not heard anything about that being even looked into.
Okay.
As far as the supervised visitation, as long as I've been in full compliance, that's why I'm not getting visitation. I'm going to mental health. I do it every week. I'm on weekly visits for an hour. I've been going to SUD. If she wants all my visitation stuff, I'll get that for her. But I like to have visitation pretty soon here. I'm working for landscape, $40 an hour. I have income, have a place to live. I'm going to SUD and have mental health appointments regularly. So I don't see what the issue is. I go to NA like twice a day, 3 times a week. That's more time than I'm even supposed to do. So I'm not sure what the issue here is. I was also been told that he's not even at the address that he was supposed to be staying at. He's at another address for my boss, and he said my son was somewhere else. And if it's court order, then somebody should let me know that he's moved or relocated or whatever you mean.
Okay. All right. Thanks. Well, this case is interesting in the fact that Mr. Tatum, in his proposed parenting plan, basically recognizes that that he needs some assistance and improvement with SUD and also with mental health, in that he required in his proposed parenting plan that he get a mental health evaluation and also SUD evaluation and comply with the treatment recommendations. And so here we have just a small snapshot of that, and it's not a complete snapshot because we don't have the mental health evaluation. So at this point, I'm agreeable to set one more review for Mr. Tatum to submit documentation supporting his indication that he's been involved in SUD since February, and also to show that he's involved in mental health. If we don't have that when we come back to the review, I'm just going to simply deny the motion. If we do have that information, then Mr. Tatum, of course, would submit that to the court and also send a copy to Ms. Tatum, and Ms. Tatum then could submit a response or some type of pleading to support her position related to the requested parenting plan, and then we can make a decision on the parenting plan at the next hearing. So that's my proposal to address the issues that have been presented to the court today. So I would propose that we come back on July 3rd. July 3rd is a Wednesday at 9:00 in the morning. Prior to that time, Mr. Tatum, you will have submitted any treatment records related to SUD and also mental health to Ms. Tatum and also to the court. And then Ms. Tatum, then you'd be encouraged, if you want to, submit a response to those pleadings and also to the proposed parenting plan. Are you both available on July 3rd?
Yes, Your Honor.
Mr. Tatum?
Yeah, I'll be there.
Okay, great. So we will see everybody then. And again, the focus of this next hearing will be the motion brought by Mr. Tatum back on February 28th for the temporary parenting plan. And key to that is going to be the SUD records, treatment records, and also the mental health treatment records. And if the parties want to submit additional declarations, I'm fine with that. And then also those records of treatment compliance will be critical. So we'll see everybody on July 3rd. Thank you.
Thank you, Your Honor.
All right, thanks. And then just to confirm, Ms. Looney, any additional cases today? Keegan and Stephen Trotter.
Okay, I
Mr.
think
Keegan's
she's-
here.
I
Mr.
think
Trotter has
that's-
arrived. I think that's a no. All right, go ahead and come up and take a seat. We're on today for a presentation. We had a hearing back on May 29th, in which it was in front of Judge Basher. And apparently a no contact order was terminated at that time. And that the parties, the indication was the parties had reached an agreement and that the parties would potentially be submitting agreed orders. And when I looked at the file earlier this week and yesterday, I didn't see anything that had been submitted. Is that
Yeah.
accurate?
Yes, so I did get all the paperwork together. There were a few things that came up when we were coming to, I don't think that anything that we turned in the week prior to the last date was visible at the time, so I don't know if he really,
If he looked at that. So, okay, so we were here on the 29th, in front of Judge Basher. So since the 29th, there's been no new submissions. Is that correct? You haven't submitted
I
anything?
gathered everything. We were gonna come up with a parenting arrangement together,
Right.
but he said he wanted a say in the medical and,
Okay.
I'll let him talk.
I just have a question. We basically are like 99% in agreement upon things. I just had a question in regards to like the decision making about like medical and schools and stuff. I wanted to be involved and be a part of that, but the schedule we agreed to, everything was the same. So I'm just curious if there's a difference between like types of like custody, or would that mean that I have to have more custody if I have a say in those things, or is like a say in the decision making separate from like the custody situation, or how that unfolds? Because that was the one hiccup that we had, is that she wants me to concede like full like medical and stuff like that, and I would like to be involved in that. Other than that, we're in agreement on everything.
So, no, I appreciate the fact that the parties are working well and coming to agreement for the vast majority of things. So one way to approach this is that if there's agreement on 90%, 95% of the issues, and there's one or two issues that the parties can't agree upon, then that would be the issue that we could come back at a hearing and address that particular issue or issues. The court would make a ruling, and then on the other portions that have been agreed, then those would just carry over, and then the court makes a decision on the contested items. To your question, if there's a certain parenting time, if there's an automatic or default setting for decision making, there's not. There's really no connection. I've seen it all over the board, where you have some people that have very little parenting time and it's joint decision making, or somebody that has tons of parenting time and it's sole decision making to the other parent. And so it's all over the board. So there's no direct connection. So if there's not an agreement today in whole, then I wouldn't be signing any orders today. If there's a particular area of disagreement or more than one area of disagreement, the parties would be free to come back to court, and you could submit declarations on that particular issue or issues. So the court's informed of what your concerns are on those particular issues. And then the court would review those declarations. We'd come back to court. You would argue your respective positions, and then the court would make a decision on those limited issues, and then sign off on an order that includes those new issues that have been decided and the other items that you've already agreed upon.
Okay, so I printed out the parenting plan. I filled everything out. Our plan was that he would have him from 8 to 6 on Wednesdays per week. The only thing is, and I don't know if you were able to see the declaration, but in his residence, it's just not baby ready. So it would be a while before he was able to take him to his house, probably. I know that you guys don't, it sounds like you guys don't step in for anything like that, for like an inspection or walkthrough or.
We generally don't. Sometimes there'll be a guardian ad litem that's been appointed that can chime in on the well-being of the child if there's issues.
Okay.
So that's kind of where we're at. At least from my perspective, today's hearing was a potential for you all to present to the court an agreed order. It sounds like you're close, but not quite there. And so if there's issues that remain, we could set it for an additional hearing. You could submit your concerns, whatever they may be, whether it's decision-making, whether it's baby ready and the like, and then we can make some decisions.
Okay, I do have the child support order was the other thing that I wanted to, because I think that he said,
before we go to child support, let me just hear from
No.
Mr. Trotter if he had something, then we'll talk about that.
I was just going to say, so if we were to come back on something, then it would just be the thing that I was asking you about in regards to the decision making. Everything else that we'd agreed upon, you said would be like, that's fine, right?
Normally, it's the hope is that, you know, if the parties agreed on particular issues, that those issues would continue to be agreed upon.
Yeah, well, we'll try to
And
resolve
then-
that too, obviously.
Yeah, and if you can agree on everything, great. If you can't, then the court can address those limited issues and you could chime in on your respective
But I mean, that's
positions.
not going to dissolve like the other stuff, like the things that we said that we already agreed upon, all that stuff's okay, right? We would just be like, paying attention to the issue that we talked about of the
Yeah,
decision
if you
making.
come back and you tell me that you're still agreed on issues A through X, great. And then it's just Y and Z that you're conflicted on,
Okay.
then we can address those issues and resolve that at the next hearing.
Okay.
And you'd both have opportunity to write a declaration in support of your respective positions on those contested issues.
So I do have the parenting plan filled out and ready to go for his time and all of that. But as far as the decision making, you said that if I were to have full custody, he still could have a say in the education and medical and all that stuff.
It's pretty common.
Okay, so I agreed to consult him about those things. I just don't know how that would work if
So
were
we're not going to
disagreeing.
resolve that issue today. It sounds like the parties, you're not agreed on that. So that's an issue. One of the issues would come back on and you'd each submit your declarations of why your respective positions should carry the day and that I'd make a decision.
Okay,
So we'll take as far as your timeframes on that, do you want to come back on the 26th of June or July 3rd? It's either 3 or 4 weeks away respectively.
Whatever you.
just do the soonest, the 26th.
Okay, let's head over to the June 26th. I'd encourage each party to submit your declarations, submit it to the courts, send a copy to the other party of what your position is on the contested issues. And then we'll address that on the 26th.
And if we should be able to like come to an agreement on this beforehand, then we can just sign the paperwork for that
Yeah.
and bring it in. Okay.
Nothing prevents that from happening. Nope, that's true. And you had an issue of child support you wanted to address briefly?
Yeah, I don't think he could see his worksheet when we came the last date. And then on mine, I don't believe that I ever itemized, because I was kind of scrambling to get everything in when I originally petitioned everything. And I don't think that I put on my worksheet my monthly bills like rent, car payment, insurance, all that stuff. I don't think I ever included that. And that's another thing that we don't know. From my calculation, I think it was like $635 a month. I don't know what his income is, but that's based off of what he's told me. That's what I was calculating, but
So as far as so there was a petition filed by Ms. Keegan related to parenting plan and child support. I don't believe I have any proposed child support order or child support worksheets.
okay, I
Have you
did turn
submitted
in,
those?
I have them here. I have my stuff here just in case you couldn't see it this time.
When
but-
did you file that? So they're proposed orders, right? Is that what you're saying?
Yeah, so I wasn't sure on an amount or anything like that. And then on my worksheet, I don't think I remembered to include all of my monthly bills, which I redid that. But as far as the amount goes, we just weren't sure.
Yeah, so anytime when there's a motion for child support, the parties submit information by which the court can make a determination of what their gross and net incomes are. So if you have information related to that, whether it's pay stubs or W-2s or 1040 tax returns, that's helpful in making that determination of what a person's income is. And so at this point, I don't have any proposed child support order nor worksheet. Those issues can be addressed at the hearing on the 26th.
I turned mine in. Did you not turn yours in?
No, I turned in back pay stubs for my recent 2 checks and filled out all my financials and everything as well. And I also did the itemized stuff, and then she flagged the spots for her side of the financials with green arrows and told me that I could just put zeros for her. When I say her, I mean the clerk that was helping me, said that I could just put zeros for Bailey's because I don't know her itemized stuff.
Right.
But yeah, but I submitted. It might have just not gotten to you guys.
Well,
yet, but-
no, I saw that. I saw
Okay.
So I see the declarations that you filed. So I'll just tell you what I have. There's a financial declaration from Mr. Trotter that was submitted. There is some sealed source documents related to his pay stubs that were filed. I have that. And then I have some information from proof of financial help. Something being paid and still owed, a debt, sorry. And then there's a sealed financial document related to Ms. Keegan's, it's like a Home Depot statement.
Yeah, so
Hold on.
I just
Hold on.
okay.
Then I see a W-2 from Ms. Keegan that was submitted, and then a financial declaration Ms. Keegan submitted. And then, okay. So in preparing for today's hearing, I did not look at those financials closely. I skimmed over them. So we're not going to address child support today. I'm not prepared to do so, and I apologize. But we can certainly address that when we come back on the 26th. And if the parties, since Ms. Keegan, I believe you are the moving party for child support, if you have proposed orders that you want me to look at of what you feel that the order should reflect, then you could submit those to the court, send a copy to Mr. Trotter, and we can review those on June 26th, and I can make a decision on incomes and set child support at that time.
Okay.
Any questions?
No, Your Honor.
June 26th, we'll talk about the contested issues on the parenting plan, and then we'll address child support.
Okay. Thank you, Your Honor.
Thank you. Thank you, please. Yeah, so we have, looks like Mr. Tyler Beck is present, correct?
Yes, sir.
Okay, Mr. Beck is in the courtroom seated, and then Ms. Whitney Bray, you're present, correct?
Yes, I am.
Okay, and let's see. All right, so we're here on Mr. Beck's motions related to a temporary order and also a restraining order. I want to double check with Mr. Beck initially, as far as time frame. It looks like you served the documents to Ms. Bray about your motion on May 27th. Does that sound right?
If that was the Monday, yes.
Yeah, the Monday. Yeah, Monday was the 27th. And so under that local rule, you may have been here present at the beginning of the document when I talked about local rule 88, which provides some timeframes as when things need to be filed and kind of lead time. So here there haven't been enough days from the time that you served her for that 21 days or then X number of days for her to respond. So I'm in a position, if Ms. Bray is interested, to continue the matter to allow her to submit her response, because I've read what you submitted, Mr. Beck. I know what you're thinking and what you're wanting, but I'm not really sure what Ms. Bray is. Ms. Beck, which do you prefer, Ms. Bray or Ms. Beck?
Yeah, either way. No, but I do have a concern with the whole thing, because he lives in Oregon in Columbia County, and I'm in Snohomish County, so I kind of just wanted to dismiss this whole thing for us to try to file in a county that one of us resides in.
Okay.
Your Honor, if I may.
Yeah, go ahead.
ESHS and the police departments both said that we should file in Washington because it would work better with theirs, not DSHS, but CPS. And the police officer that I was speaking with both said that I should go to Washington to file all this. That way it would be reflected onto the CPS case that's currently going on.
Okay. Does either party have any connection to Cowlitz County?
No.
Okay.
I mean, I live right across the bridge, but
yeah, other than the contiguous border. Yeah. Huh, that's interesting, because usually the idea is that where a case is brought, it'll be a convenient forum for witnesses who may live close to have information about the child, or there may be daycare providers that could provide information or the like, or schools that could provide information. And so usually that's kind of the idea behind filing a case in a particular county or location, is that it's a convenient forum that allow for a prompt resolution, swift resolution with convenience for everybody involved, relative convenience. Of course, not always convenient.
Yeah, because you guys are the closest courthouse. Other than that, it would be St. Helens in Oregon.
And
so
for me, it's like a 4-hour drive.
Go ahead.
So it would be an hour drive from where we live compared to the 20-minute drive to here. So that's why we chose Longview, plus what CPS and the police officer told us about.
Right. Okay. So one thing we know as far as the motion today, it's premature as far as timeframes. Ms. Bray has not had sufficient time to submit a response. So that's one. So we're not going to address any substantive issues today.
So I have one thing. We submitted those forms quite a while ago, but we didn't get those forms until Friday before that Monday that she was served.
Okay.
Yeah, we don't know what happened with that. It was like a week or two before we even got our forms back from the clerks.
Okay. So yeah, that doesn't necessarily change the analysis as far as a sufficient time for Ms. Bray to submit a response, notwithstanding those delays otherwise. So we're not going to address any substantive matters that have been raised in the motion because we haven't heard from Ms. Bray yet. I guess the other concern is I just wanted to have brief consult with Madam Clerk. Can I ask you a quick question? So I think what I need to do is that I think there's a fairly strong basis to have this case transferred to a different court within the state of Washington, because my understanding, or I need to do a little more research on that. Okay. I'm not quite prepared to address that particular issue. I'm just trying to think of the best way to handle that.
If it helps at all, like we both were from Snohomish County, and that's where before Tyler moved to Oregon, and I wish he would just come up here to finalize our divorce and get our parenting plan going.
You kind of threw that at me kind of fast. I wasn't quite ready to absorb that. Could you repeat that again?
Oh, just me and Tyler, our relationship and everything. We lived up here in Linwood area, so we were from Snohomish County together. I was hoping that he would come and file our papers because it'd be very convenient for me, and he has his mom he could stay with, and just get our divorce going and our parenting plan and settle it like we were going to before, instead of trying to get me to go farther out, because it's like a real far. I'd have to take time off of work just to file papers, and it would just be a big hassle to have to go to any other county, especially even if he did go to Oregon. So,
right.
Yeah.
Thank you for that input, Mr. Beck. As far as the your child in common is Hendricks, has he spent significant amount of time up in Snohomish?
He has spent most of his life, yes.
Up there.
Unfortunately, I know it would be more convenient for Miss Bray for me to go up there, but I do have a 5-month-old that I'm not going to be able to take 4 hours there, 4 hours back,
sure,
and be able to make it to a court date such as 9 a.m.
Okay. All right. One moment. As I explained earlier, the idea when we have a parenting plan, we want to be in a place where it's convenient to gather information and have people who have information about a case come in and testify and share information to the court about what's going to be best in the best interest of the child. So my understanding is that the child here is 10 years old, and the vast majority of his life has been spent up in the Snohomish County area, where there's maybe school records, maybe there's dental records, health records, and the like. So it seems to me that it's likely appropriate to transfer the case to Snohomish County. But before I do that, I need to do a quick review of some statutes and the like to make sure that that's right, because I'm not quite sure, to be honest. So what I'd like to do is research that and then issue a letter and potentially an order explaining my rationale for either transferring or not transferring the case.
Okay.
And so I have some addresses here, and I could maybe, I've got an address for Mr. Beck in Clatskanie. I've got that address there. And then for you, Ms. Beck, is there a best address that I could use to forward that information to you, or an email address?
Email
@gmail.
Yes, Your Honor.
Okay. So I think what I'll do, I'll send out, I'll research that. Hopefully by the end of business Friday, I'll have that done. I could have it done sooner. And then I'll just send that to the parties, and I'll give you my decision related to whether the case stays here or whether it transfers up to the Snohomish County
And if
Court.
it were to transfer up north, would there be an option for Zoom, or would I have to drive 8 hours a day?
My assumption is most courts have the Zoom option, just since the pandemic, everybody kind of realized it's a lot easier. And so I think most courts allow that. I'm just doing a quick Google search to see what I know about that, because I think
And as far as the temporary custody order and the restraining order, is that set until the next court date?
yeah,
Okay.
good. That's a great question. It's a great question. So there's a temporary restraining order that was issued back on May 23rd that indicates has some prohibitions that are upon Ms. Bray, and that indicates the child remains with Mr. Beck until the hearing. So, I mean, do you have any questions on that, Ms. Bray?
Yeah, actually, the way they served me the papers, Tyler was there with our son Hendricks. They said they're going to come visit me, and his girlfriend served me right then and there, and just kind of used our son as a ploy. So I feel like it's just I would want Hendricks back home with his siblings and me, really. And I feel like it's a bogus claim that he's making for just to keep Hendricks with him.
Okay.
Because we have more children together. We don't just have Hendricks. We have Maddox back too, and he doesn't really put too much about Maddox into his parenting plan I've seen, and it's kind of just concerning.
All right. So yeah, I appreciate the input from both parties. As far as that temporary restraining order, since we're at a point where we don't know if the case is going to continue here, it's going to be transferred elsewhere, I'm going to reissue that temporary order of protection that was issued on May 23rd until I get the next step in, which will be my order related to the transfer, the retention of the case here. So I'm going to reissue that order, so all those same prohibitions apply.
So I can't call him or anything. I can't talk to my son anymore until the next court date.
Well, it'll be the contours of that particular order. It indicates here.
Jerry was the
There's
mediator.
no way to like indicate that they didn't serve me correctly at all.
So I'm showing here that the Columbia County Sheriff's Office, let's see. Okay, so they got that. And then I see proof of service that a Geraldine Beals served Ms. Whitney Bray on May 27th at 7:19 p.m.
And there was a police report involved with that.
Yeah, with
due to
so I'm not going to get into the details of that. As far as service, there's an affidavit that's presumptively accurate. So I'm going
It doesn't matter that she's the girlfriend of Tyler, though, that she's that she's like in the party's favor, you know?
Yeah,
I feel like it was wrongful.
it doesn't. Yeah, the rules are that it can't be the actual party. It could be somebody closely aligned with them.
Okay.
That's fine. Okay, so I've reissued that order, and then we'll need to. So the prior order is still in effect. I'm going to set a date for review just to make sure we don't lose track of the case. So I'm going to be issuing that order related to whether the case stays here or moves up to Snohomish. And I'll issue that, like I said, hopefully before this Friday. And then let's come back on the 26th, the 12th of June, just one week from today, June 12th at 9 a.m. See if I want to verify both parties are available. Mr. Beck, are you available?
Yes, Your Honor.
Okay, and Ms. Bray, are you available?
Yes.
Okay, so we'll set it to that date, June 12th. And we'll just kind of verify we're all on the same page because I don't want something to get lost in the mix. And then we'll come back and on that date and kind of verify what the next steps are. Any questions at this point, Mr. Beck?
No, Your Honor.
Ms. Bray, any questions?
No.
Okay, we'll see everybody next week. Thank you.
Thank you.
So we'll just verify who's who. So why don't you tell me your name?
My name's Corinne Kell.
Last name again?
Kell.
Kell. And in some of the pleadings, it may be under the name of Speck.
Speck or Jackson.
Or Jackson. Okay, great. Thank you. And then your name, please.
Carla Snyder.
Okay, you're Miss Schneider. All right, anybody else here on this matter? Dalton Thompson or Daniel Ingram, either of you present? If so, please unmute and state your name or come forward. Okay, nobody in the courtroom's moving. I'm not seeing anybody on the Zoom call that's closely related in spelling and I don't hear anything from the Zoom. So let me just pull up my notes one moment. Okay, so this is on today for Ms. Schneider's motion for contempt. And when I was looking at the case, Ms. Schneider, I was looking for proof of service that you had served the documents that you had filed on Ms. Kell. And I didn't see anything when I looked at the file. That doesn't mean that I didn't overlook it. So do you have proof that you had filed and pardon me?
Yes, I actually have copies because I already submitted to you guys, but I always keep a copy of it.
Okay. And let me just double check. So, okay. So sometimes I review cases on Monday, which I did in this case, and then stuff gets filed like yesterday and stuff got filed. So I've missed that. So I see the proof of service that a Mr. Specs, okay, hold on. Hold on. So I see two declarations of service. One is filed by Ms. Schneider. It says Richard Speck served Ms. Kell on May 31st by giving her documents, the declaration of Ms. Schneider, motion for contempt, order to go to court, the contempt hearing order, and confidential information. So I see that. And then looks like Mr. Dalton was also served on June 2nd. Okay. So it looks like, Ms. Kelly, you received the documents from Ms. Schneider related to the contempt. Is that accurate?
Yes, like Thursday or Friday last
Okay.
week.
And then was it your plan to submit something in writing in response to her motion?
I didn't know that I could. I can if.
Yeah, so there's
possible.
generally there's two options. The court is document based. So generally the court will look at declarations from one party, declaration or motion from one party, and then declaration or response from the other party. And then I read those, I'm prepared for what each party has to say. And then you come to court and then you just kind of summarize and make your argument and just kind of re-emphasizing different items that you had made in your declaration or the like. The one thing I wanted to double check with is timeframes. And so we've got the order to show cause, which was issued on May 21st, and then to come to court today. And then we had the service of those documents upon Ms. Kell on May 31st, which was over the weekend, I believe. Or would have been last Friday. So generally in circumstances like that, I'll allow additional time for somebody to file a written response. So I know what both parties are asking for or what's happening. Here, the issues alleged in the contempt are not of, at least in my mind, of an emergent nature where there has to be a decision here just immediately, or otherwise the child is going to be harmed or something bad's going to happen. That's related to missed visits, which, are concerning if those are accurate. So if hearing from Ms. Kell, it sounds like she has a desire to submit a written response. And since the time frame was fairly short from the 31st of May till now, June 5th, with a weekend involved there, it seems appropriate to allow her some additional time to submit something, and then we can come back and address the issue. And I know you spent your entire morning here today, and I apologize for that. Takes time. So that's where I'm leaning at this point, is just to continue this matter, to allow Ms. Kell to submit a document to the court, serve a copy upon Ms. Schneider, and then come back and hear the matter. Any strong disagreement from either party or objection?
Nope. No, I don't disagree. I served her as soon as I was able to actually come and get the copy that you signed.
Okay.
Because they told me I had to have that signed copy to serve her. I couldn't serve her the non-signed one. So.
Right. Yeah, lots of moving parts with all of this. So we're looking then, normally we would set this over 2 weeks. The 19th would be 2 weeks, but that's a holiday, so we don't have that docket. So then we'd be looking at the 26th of June. So are you available on that date, Ms. Schneider?
Possibly. I have total knee surgery coming up on July 1st. So I have a whole bunch of appointments before that. So
okay.
That's my dilemma right now.
Okay. All right. Thank you.
Is it possible if one of us aren't able to come into the courtroom for court, can we come over Zoom?
Yeah, anybody's free to come in
Okay,
via Zoom.
For any days.
Okay. All right. Do you know right now, Ms. Schneider, if there's a specific conflict with your pre-surgery appointments on the 26th, or is it something that's going to be scheduled that may conflict?
Yeah, it's something that might be scheduled. Like I have an appointment, I think on the 27th or like right there on those couple days. So I would have to check for sure, but.
Well, why don't we do this? Let's set it for the 26th at 9 a.m. And if there's if you have a conflict with that, then you could let the clerk know, and then they could let me know, and then we could reach out to the parties and potentially move that. Okay. But for now, let's plan on that. Let's plan on the 26th to address the motion for contempt at that time.
All right. The only question I have and kind of concern I have putting it off is I'm still not getting none of my visitation. I haven't had them in the last 4 visits have been denied.
Yeah.
Since I filled all this out.
Well, let me ask the parties. The other option would be to set it over 1 week. That would mean that you, Ms. Kell, would need to have something, your declaration or your response prepped and ready to go and submitted basically by Friday, at latest on Monday.
Okay, I can try to get it done by then, but no guarantees, because I do babysit at home for 4 girls Tuesday through Friday, 9 a.m. until 3 p.m. every day.
Okay. All right.
So my only days available to do like paperwork and stuff like that's Monday. I'm completely free on Mondays.
Okay. So potentially you could work on your declaration in the evening hours between now and then Monday, and then file it on Monday and then get a copy to Ms. Schneider.
Yes, sir.
Okay. Yeah. Yeah. So on the 10th, when you come to court, bring an extra copy for me, just a hard copy, because it goes through a scanning process and it takes a couple days sometimes, so it's not uploaded immediately.
Okay.
And that way I'll be able to review it, and that way Ms. Schneider can see it also.
And now, since this is just pertaining between me and her, do I need to serve Dalton Thompson since he won't be showing up to any court dates over any of this? Because it's just a visitation between me and her. I have full custody of my children and the father's no longer involved.
Does he have his parental rights been terminated?
No, he hasn't terminated or anything. He's just hasn't been involved since I got custody of them 3 years ago.
Yeah, I think he needs to be served if he's still involved. Yeah.
Okay, just wanted to double check.
Yeah. Okay. So we'll see everybody on June 12th, a week from today.
Okay, June 12th, 9 a.m.
Yep. Yep. Okay. See everybody then. Thank you. Present. All right. Okay. So we have Mr. Brandon Connolly. That's you.
Yes.
Okay. Good morning. And then we have Miss Jessica Baker, and that's you.
Giles.
Giles. Thank you. Miss Giles is present. So I'll just give myself a little note so I don't make that same mistake.
Probably like that because it's from when I was married and through Pierce County.
Back in 2015. Yeah. Okay. All right. So we have Mr. Connolly and Miss Giles, and this is on for Mr. Connolly's motion for contempt. And I'll just confirm that Ms. Giles, you received a copy of Mr. Baker's information and motion. Mr. Connolly, sorry.
Yes, but his mom threw these in my lap when she walked in, and this doesn't pertain to anything in there. I just want to mention that.
All right. So it looks like services is proper. And this is based on the parenting plan order that was issued back in July of 2018. That's the basis. And the allegations are related to visits denied, and then the explanation from Ms. Giles, her viewpoint. Okay. So I've read. I've reviewed it. All right, thank you. So I've reviewed the pleading, so we'll hear from Mr. Connolly as to your motion, and just go ahead and just lay out why you feel there's been contempt, and then we'll hear from Ms. Giles and why she feels there has not been contempt.
She let me have visitations with my son up until she found out that I was having another kid, and then all of a sudden she just quit letting me have visitation.
Okay. And so the parenting plan says first, third, and fourth weekends, Friday 5 to Sunday at 5. And that's your parenting time, correct?
Yeah, she's been letting me have him whenever it's convenient for her.
Okay. Okay. And then there was a paragraph 4 required you to get a SUD evaluation and treatment and do anger management evaluation and treatment, and then provide copies of the evaluation and compliance reports. Is that accurate?
Yeah, that's true.
Okay. All right. And then, so you're saying from February 2nd through the 4th, the 16th through the 18th, the 23rd through the 25th, and March 1st through the 3rd, that's when the visits ended. So your last visit was in January 28th.
Correct.
Okay. And that's the same time frame when your partner or you were aware of your partner's pregnancy. Correct. Okay. And then you're asking for makeup visits for those missed visits. Okay. All right. Anything else you want me to know about that scenario? Okay. All right. And then we'll hear from you, Ms. Giles. What's your
So my son gets ABA therapy, and they
ADA?
So
which stands for?
It's a therapy for autism where they come in the house and they work with him.
Okay.
And the therapist did like a safety inspection, which I have in here. If you want to see it, it's also filed.
I read it.
Okay. His place was not safe. They couldn't do services there. So I took pictures when I did take him, and
When did you take those pictures?
They're dated.
Where's the date on those pictures? Is it at the bottom, top?
Yeah, January 26th.
January 26th?
Yes.
Okay. Go ahead.
It's my son couldn't cook. He couldn't get his own food. The kitchen was filthy. His bedroom, he couldn't even go in there and do anything. It was full of everything. If you look at the photos, you'll see.
I saw that.
And due to the safety concerns of that and ABA not being able to provide services, I told him that when his house was clean to let me know and he can resume visitation. And I've been doing it out of kindness of my heart because he's never provided information of treatment and anger management like the parenting plan states. And so that's why he didn't have visits. And March 15th or 16th, I had got a phone call from the ABA therapist. She's the supervisor, saying that his house finally passed inspection. They can resume services there. And so then in April, my son had a visit there. And he's been in baseball, so baseball games, Brandon can't provide transportation because he doesn't drive, he can't, because he's had DUI, can't have his license. And so he can't get him to the games, but he doesn't even ask for him, so.
Okay. And so
And
you're,
then when he does ask for him, if you don't give him to me, I'm gonna file a restraining order against your boyfriend. So it's threats against me. And lots of taunting.
okay. So you take the pictures, there's concerns based on the cleanliness of the home.
Yeah, CBS was
And then
called,
on
yeah.
March 15th, he passed the inspection. The ABA counselor said, okay, we're okay, we're good to go.
Yeah.
You allowed a visit a month later, about April 19th.
Roughly. Yeah.
Okay. And then on May 17th, Mr. Connolly asked for a visit and you said, no, not until you get proof of the evaluations and the
Correct.
treatments that were ordered back in 2018.
Correct.
Okay. All
And
right.
CPS was called too because of the condition of his house. And so because I live in Clark County and he's in Cowlitz County, there was two separate workers.
That's not why CPS was called on her account. It
So
was due to her.
do you mind just holding off?
Yeah.
Keep that thought. Keep that thought. I want to hear what you have to say. And then, so the CPS, what's been the outcome from that? Is there anything at this point?
Not on my end. It's been closed on my end because the kids aren't neglected or abused. On
Okay,
my
so it's
end. I don't
closed.
know what happened on his end.
Okay.
Because
What do you?
it's two separate
It was
workers.
closed.
Okay, it's closed. Okay. All right. Anything else, Ms. Giles?
No.
Okay, Mr. Connolly, anything in response?
Yeah, her CPS case was not open due to me at all. It was due to allegations of her boyfriend hitting my son or something. I believe that the counselors are the ones who actually called it in. So
Okay.
it had nothing to do with, my CPS case.
Meaning cleanliness?
Yeah, it had nothing to do with mine at all. Her case was completely separate from mine.
Okay. Do you agree with that?
No.
So when you called in, did you call in to
No, my
CPS?
son's ABA therapist.
The
told me
ABA
the
thing.
condition of his life.
Okay.
Yes, because they had major concerns of hoarding and everything like that. So.
Okay. All right. Okay. I kind of cut you off. Anything else?
The counselors are actually the ones who called CPS on her. Not, for the allegations of Travis hitting Riley.
Okay. In all accounts, the CPS, both.
They were closed.
They're both closed. Okay. All right. So, okay. I appreciate the input. It's nice to reorient me after I've read it and I've taken notes on what the parties had indicated. So back in 2018, when the parties, when the court ordered the visitation schedule and also the evaluations to occur, and it says, if these evaluations and the treatment requirements don't happen, then there's not to be any visits. That's the language that's used in that order. Like a lot of orders, there's deviations from them, right? There's kind of these base orders, and we recognize that life is kind of happens, and we modify things. Parents modify court orders all the time. We recognize that, and that's okay. But if there's ever a disagreement, then they have to go back to the court order, right? And that's kind of recognizes the changes of life and the like. So it sounds like at that time the concerns was the SUD or alcohol or drug issues and anger management issues. And so if there was any issues, then there would be that he would need to, Mr. Connolly would need to engage in those services and show that he's compliant. And if he didn't, then Ms. Giles could say, done, we're not doing any visits till we get that stuff done. So what I think is interesting is that from 2018 until just recently, on or about the same time frame when there's an alleged information about a new pregnancy, the visitation stopped. That seems to align also with the visitation from the ABA counselor that visited the home. I'll tell you, the pictures are not impressive. I mean, they are impressive in one way. It's pretty messy. It's dirty. It's unkept. However, the concerns of the initial parenting plan seem to be focused on SUD and anger management, not necessarily cleanliness issues. If cleanliness was an issue, that would have been contained within the 2018 order of the parenting plan. So what it seems to me is that we don't have any proof that Mr. Connolly is engaged in those treatment modalities. There's no showing that there's been an evaluation.
Probation, so I don't know if I could use that. I got off probation like 2 or 3 years ago. So.
Yeah, generally probation is kind of an umbrella under which maybe anger management might be a part of it. So
yeah.
So at this point, at least in this court file, this family law case, I don't have any records that show that you've completed the SUD evaluation treatment or the anger management evaluation or treatment. So I think that it's interesting because the parties, you jointly and temporarily modified the parenting plan by skipping over the SUD and anger management evaluation requirements.
I think it was in like 2021 or something like that, that I had a no contact harassment order against him because he was harassing me when I lived in Longview, and that was for a whole year. He didn't see the child or anything like that. So
Okay.
I think I put that in my response.
Yeah. Yeah. And so from 2018 till now, the parents have decided to modify the parenting plan, have decided to deviate from that program, specifically by skipping the requirement or overlooking the SUD requirement, anger management. So at any point in time, Ms. Giles could say, hey, nope, we're not doing any more of these because we don't have, because there's still these SUD issues that are anger management issues that are still coming up, and which they may still be in play based on the no contact order or the like. What I sense here is that Ms. Giles' denial of the visits to the return of to denial of the visits based on the parenting plan was not necessarily in response for the failure of not doing the SUD and not doing the anger management, but was instead based on cleanliness concerns. I think that was the motivation. And there might be a little something about the pregnancy. I don't know. Probably there may or may not have been. So when I looked at those, and I'm going to look at those pictures again, but when I looked at them previously, I noted that it was, it was very unkempt. Things were not put away. Let me just pull it up again.
I have colored ones if that helps.
I'm good looking at the black and white. Thank you. Okay. Having reviewed those again, my sense here is that was the apartment dirty and out of control? Yeah, it was. The child is how old?
He's 11 and he's
11.
level 2 autistic, and he has a genetic seizure disorder and ADHD. So he's special needs.
So level 2, what does that mean as far as his ability? It sounds like he could prepare his own food.
Yeah, he can.
To a degree. I mean, he's not doing some fancy meal, but he can.
He can't. He can put stuff like in the microwave, but like he can't cook on the stove. So.
Sure. You can do some toast and do.
You can cook like eggs and stuff.
Okay. So my sense is that there's this dirty apartment. Mom finds out about that, not happy about it. Says we got to get that fixed. What is absent is any showing that there's an SUD issue or an anger management issue that contributed to the cleanliness issue. So the motion for contempt is based on the failure to provide visitations concerning related to the SUD evaluation and the anger management evaluation. Granted, Mr. Connolly has done nothing other than probation to address those issues. So that still remains. That's an issue. That's an issue that you need to get on. And I think that's really important that you get on those things, because if you don't get on that, then Ms. Giles is going to be in a position to say, look, you don't have the evaluation done. Visits aren't going to happen.
Can I have evaluations, I've done them since then, can I turn those ones in? Like I have
Sure.
evaluations back from when I was on probation.
Sure. Yeah, those would be all important information for the court to know if there's any further occurrence or future concerns related to the parenting plan. Because as it stands now, the parenting plan can be invoked based on the language if there's not those things in place, that there could be a denial of visitation. But like I was saying here, that is that the denial of the visits was based on the cleanliness concerns, and it was not associated with the parenting plan concerns of SUD and anger management. And I recognize there's a degree that potential of SUD issues could relate to non-cleanliness issues. I recognize that there's a potential connection there, but there's not a proof piece, if you will, that connects those two. Of like somebody that says, like a declaration that says, well, I think Mr. Connolly is drinking or using again, and therefore that's just leading to the lack of cleanliness. So there's a lack of a bridge that connects those two. So I think that's important in that the dirty apartment, while it's certainly not best case scenario and kind of gross, I didn't get the feeling there that it was a direct danger to the child. I mean, there may have been, but I didn't get the sense from those pictures and the like that it was not a direct danger, in that there was a bed for him to be in. Were there dishes in the sink? Yeah, there was a lot. Could they have been moved and could get a glass of water? Yeah, he could have done that, and it's certainly not beneficial to him. It's been cleaned up now, is my understanding. So it's kind of a fine line that I'm drawing here, because the parenting plan focuses on the SUD and the anger management, and then the reason for the denial of the visits is cleanliness. And I recognize there may be some crossover, but there's that missing piece that said, due to Mr. Connolly's SUD or anger issues, it has led to the condition of the home. So because of that, I'm going to make a finding of contempt that there was the wrongful denial of the visitation, and I'll order makeup time. And so it's going to be 1 weekend extra makeup for 4 months. So it'll be the second week of June, then in August, then in October, then in December.
It'll be when in June, sorry.
The second week, because I think you're doing the first, third, and fourth is the normal visitation timeframe. So it'd be the second weekend of June, then in the second weekend of August, then the second weekend of October, then the second weekend of December, and that would be all that would take care of the missed visits. And be aware, Mr. Connolly, related to that parenting plan as it stands now, that if you don't have those pieces in place, there may be a motion to deny visits.
File this as soon as possible.
Yeah. Okay. Yeah. So that's the court's ruling. Any questions on the ruling?
Is that this weekend?
So we've got, let's see. What are the parties have been doing? Because it's the first, third, and fourth.
No, it hasn't been followed the first, third, and fourth. It's been going about like every other weekend because my son has baseball games.
Yeah.
And that was another reason, like he doesn't drive and nobody was meeting me at the Walmart like they're supposed to. And I wasn't gonna keep providing the full transportation. So
yeah, and there may be a need to modify the parenting plan or kind of make some adjustments, but
when that was filed, I was here.
There's lots of issues. We could blow this up and we could talk about a lot of stuff today, but we kind of necessarily need to limit it. So the second, I'm going to just look at the calendar and say use Friday the 7th being the first weekend of the month. So the second weekend of the month would be the 14th through the 16th, and then the third. So when I'm speaking, do not interrupt me.
We have a trip.
Do not interrupt me. I'll finish my sentence, and then if you have a comment, please feel free to share it. I'm really good about listening to people, but when I give people a lot of time to share, a lot of judges don't allow people to speak very much. So I'm very much in favor of hearing from people, but please do not interrupt me. So you had a question, and the question you posed is what is going to be the second weekend of the month. Second weekend of the month, I'm determining that by the first Friday of the month, which is the 7th. So the second weekend of the month is going to be the 14th through the 16th. And then you had some concerns about baseball.
Yeah, so he's done with baseball, but we have his Make-A-Wish trip coming up next week, and it's Wednesday through Saturday of next week. So
probably not interrupt that. That's be a good idea to avoid that. Maybe we could move that June makeup to July.
Actually, I just had a trip and he was supposed to go with me, and she, kind of messed that over, to California.
We can skip the June visit, and we can do August, October, and then February. How's that?
That's perfect.
Okay. So we'll do the makeup. So that'll be August, October, December, February. It'll be the second weekend of each as makeup. So I'll draft a contempt order. I'll send that out to the parties. I think I have addresses here from each of the parties. Ms. Giles, we've got a Vancouver address.
Yeah.
Okay. And then Mr. Connolly, do we have your address here? Okay. I'll send that out to the parties. Okay. So I think we're done. Any final questions, Ms. Giles?
July, I want to say 3rd through July 18th. Me and my son will be in Texas.
Okay. So there's going to be lots of issues. We're here today on the issue of the contempt motion. So I'm going to focus my comments related to that. Any other issues, I'm going to allow the parties to kind of work on that separately. Mr. Connolly, do you have any questions?
So we're going to start this July, correct?
Well, the parenting plan is in effect. And as far as the makeup visits, they're going to occur. The first makeup visit will be in August, October, December, February, and I'll lay that out in the order. Okay. Any other questions? Okay. That'll conclude things. I'll get that order out by close of business Friday, and I'll send a copy to the parties.
Thank you.
Great. Thanks.
Will that be in the mail?
I'm going to mail it. Yeah.
Okay.
Yep.
It's hard for me
Okay.
to
Welcome.
come
And then
up
I'll
here.
ask if Bradley Evans is here either on call or in the courtroom.
He was advised to be in court last time we were here.
Okay, so I see Mr. Evans is on the Zoom call. You're unmuted as far as the icon, but I can't hear you.
That was his problem last time.
Was it?
The judge highly advised him to be
Yeah.
here.
So, Mr. Evans, I can see you, you're unmuted, but I'm not hearing any audio from your end of the spectrum.
He never responded either. He's homeless right now. He's been evicted, and I don't know where my daughter is either.
You can dial in, that's fine, Mr. Evans, if you want to dial in. Ms. Norris, do you mind if I just call another case, give him just a moment to dial in, and then I'll recall the case?
Yeah.
Appreciate your patience, thank you. Okay, you're Spencer Seckney, correct?
Yes.
Okay, Mr. Seckney is present, and then Monique Marquez, are you on the line? Okay, looking at the participant list, I'm just going to type in Monique. No response there, no hits. And then just once again, Monet Marquez, if you're on the line, please unmute and state your name. I don't see her on the call, so I'm going to make an assumption that she's not on the call. And then in the courtroom, I don't see her present. So here we're on for her motion related to contempt. Right. And she filed her information and she's not here. Have you had any contact with her?
Yeah, over the weekend, I had asked the courts to do the email proof of service last time we were here in May, and she denied that. She didn't want to do that. So you asked her to do a proof of address change, and I still have not got a proof of address change. So Friday we tried to give her the response, the service of response, and we had to have local Longview PD come and assist, and she still denied being inside the house. She was home and would not open for Longview PD. We tried again then Sunday, and we got the papers to her Sunday, so she is aware of the court date.
Yeah, I see that you filed those declarations of service.
Yeah, she had sent a text message acknowledging that she was home and knew that we were there, and if she wanted the proof of address change to come meet her. I then had said, well, we're busy all day with the birthday party. That's not going to happen, you know. And then so we tried again Sunday. There was a big incident there Sunday again. Longview PD had to show up again.
Okay. All right. So it looks like she.
Sure, it's 3 years of the same thing.
So
with the proof of service.
So we were last time we were here was about May 15th, I think.
Correct.
And we were here, and you were here, and she was here. And we continued the matter to today at 9 a.m. Have you seen her at all today in the courtroom or in the courthouse?
No.
Okay, she hasn't. So she did file a notice of a change of address a few days after that hearing. So that's been filed. So you can check that out to see where she's at. You have a pending case for a motion for adequate cause to change the parenting plan, which it's set for next week.
For the 12th, yeah.
Right.
That was the original. We filed that, and then it was like she filed this and the response all in one. So we were trying to do it all in one, and then I hadn't got my response quick enough. So
gotcha. Yeah,
I got it amended and got it in there as fast as I could after that.
Right. All right. So any information that you from the clerk's office, any phone calls that she's on her way or can't make it or is waylaid with something? No emails. Okay. So based on her failure to appear today, I'm going to deny her motion for contempt. So let me just take a moment to fill that out.
Your Honor, when you're finished with that, I have a question.
Okay, great. I'll let you know once I'm finished, and then let me know what the question is. All right, so I just wrote the motion for contempt filed by Monet Marquez, filed May 1, 2024, is hereby denied based on Ms. Marquez's failure to appear. Your question?
Okay, and so with my response that I just filed, being the response to her motion for contempt, and a lot of these details in here still go with the previous motion to change the petition to change the parenting plan. So can we keep this in evidence?
It's all filed.
Okay, so
it's all filed.
So when we come back for the 12th case, I can use some of these notes, and this is still going to be recognized.
Yep.
Okay.
Awesome. Correct. Okay. Any other issues?
No, that's it.
See you next week.
Thank you, Your Honor.
Okay. All right. It looks like we have parties present. You're Dean Sickles?
I am Devin Sickles, yes.
Devin, thank you. Let me change that here. And then you're Kimberly Wanzer. Okay, all right. Both parties are present in the courtroom. So in looking at this, I see this is a motion brought by Ms. Wanzer related to for a temporary order, specifically the parenting plan, payment of different items related to the house principally, and use of property. One thing when I looked at this previously, I was looking at service. I always look at service to see, make sure that the other party's been served. I didn't see, and I'll pose this question to Ms. Wanzer. As far as service of your motion upon Mr. Sickles, did you provide him with the documents, and did you file what's called a proof of service or declaration of service?
I didn't turn it in. I had forgotten my tax return and my check stubs.
Okay.
I was gonna bring it all back.
Okay.
But I was in the process of transitioning from a graveyard position to a day shift. So I was working 2 full-time jobs at the same time.
Okay.
And I just didn't make it back over here.
Okay.
I brought it all with me today.
Okay. Then, Mr. Sickles, did you receive copies of the documents from Ms. Wanzer?
She did bring me papers to work, yes.
Okay. How long ago was that? Roughly? Yesterday, a week ago?
Oh, no, it's been a few weeks.
Few weeks, okay. And then, okay. And then did you file anything in response?
I was not aware I needed to respond to the response of my response.
The response of the response of the response. Okay. So there's a motion that Ms. Wanzer filed on May 9th, and she's asking for a parenting plan and use of property and disposition and payments of things. You received that motion. Do you know if you received that motion?
Yes.
Okay. And then she's also submitted a proposed parenting plan. Did you get an opportunity to look at that?
Yes.
Okay. And then there's some financial information, declarations that she submitted related to pay stubs and the like. The one thing that is really critical in this situation is that I have to have a proof of service or declaration of service. And it sounds like Ms. Wanzer, due to kind of work schedule and the like, you did not get that filed. It sounds like, you've received the documents, but in court, we always cross the T's and dot the I's. And that's one of the T's and one of the I's that we need to cross and dot is that declaration of service. So, and you're probably well aware of this from hearing me talk today, is that it's a paper-based system. It's a written word system that Ms. Wanzer has filed everything, so I can read it beforehand to know what her viewpoint is. And then ideally you submit something in writing so I can review it and be prepared, and then come to this hearing knowing what each party wants, and allows me to kind of weigh things with kind of the deliberation time.
So I'm a little confused because I was the one who originally filed the papers.
You originally,
he answered my papers, so I need to answer her papers again. Okay.
Yeah. So you filed a petition, right? You filed the initial petition. And so that kind of is still out there. And so the case is active. And at this point, either party can bring a motion for temporary orders, which Ms. Wanzer has brought a motion for temporary orders. You could have brought it, but she decided, because everything's at issue, because you filed the initial petition, right, for divorce. So everything's at issue. And then any party can move forward with a kind of a motion like, hey, we need some temporary help with the child, with the parenting plan and the like. So she brings forward that motion and supplies you with her viewpoint. And then it's your opportunity to supply the court with your viewpoint. So I don't have proof that you've received all those documents. Sounds like you probably have received them, but then I don't have your viewpoint submitted to me about what your position is on all the things that Ms. Wanzer is indicating that she wants. And I think we're not going to have the hearing today because of those procedural deficiencies. We need to get that affidavit of service filed by Ms. Wanzer indicating that, that the service was proper. And then we have to have Mr. Is it Sickles or Cycles? Sickles supply his perspective. So I know what he's thinking. And then Ms. Wanzer has an opportunity to actually reply to whatever you submit. So I think probably the long and short of this discussion is that we'll continue the hearing, allow the declaration of service, proof of service to be filed, allow you to file your response, and also serve Ms. Wanzer copies of those documents, and come back and have a discussion and make a decision on the parenting plan issues, on the mortgage and all those other bills and the cars and stuff. So I know you spent an entire morning here today. It's not probably the best use of your time, but I want to talk to you about a date in which we could come back. Generally, with response times, 2 weeks works best. That would take us to the 19th. That's a holiday, as you've heard me say. So we could look at the 26th of June if the parties are available on that date. So I'll ask you, Ms. Wanzer, as the moving party, your availability on June 26th.
Yes, and we saw online that there's a court date scheduled already for the 12th.
Okay.
But our son that we share, his 5th grade graduation is the morning of the 12th. And it looks like we would definitely not be able to attend. It would be here half the day.
Okay. So that June 12th, it looks like you noted that up, Mr. Sickles, correct?
Yeah, it's a Zoom.
And is that's for, oh, so it's a trial assignment. Oh, it's for a mandatory settlement conference. Okay. Okay. So I don't know what your position, you noted it up, and I don't necessarily want to interfere with that, but if there's a conflict, we could, you could appear via Zoom for that. And then that would be for a setting of a mandatory settlement conference at sometime in the future. So
What's a mandatory settlement conference for?
it's another opportunity for the parties to sit down with a judicial officer and work through the issues and see if you can come to agreement on any and potentially all of the issues that are before you. So it's a time where you come together and you have a kind of a person that works in between you and tries to work out an agreement with the two of you. So that's what that's about. So I think we'll just leave that as is. If the parties feel that there's a problem with that, conflicting with the child's activities, otherwise I'm just gonna leave it as is, and the parties can make a decision if you want to carry it on with that if it conflicts. Otherwise, we'll just leave that, and that's already been noted. And then let's just talk about the next step in this particular motion that Ms. Wanzer had brought. So the 26th of June works for Ms. Wanzer, and I'll see with Mr. Sickles if the June 26th works for you.
I will make whatever I need to happen to make it work.
Okay. All right. So we'll come back on June 26th at 9 a.m. And at that time, I'll assume that Ms. Wanzer will have filed your proof of service, and then Mr. Sickles, you'll filed your response to her motion, and you'll submit a copy to her and submit a copy to the court, and then we can have a discussion and make some rulings on that. So any questions at this point, Ms. Wanzer? Okay, Mr. Sickles? Okay, we'll see you on the 26th of June at 9 a.m. Norris is present. Thanks. And Mr. Evans is on the line. Mr. Evans, can you hear me? All right.
I can hear you.
Okay, and I can hear you also.
Awesome.
All right, give me just a moment to pull up the case. This is a motion brought by Ms. Norris for a temporary parenting plan. A lot of focus is on Ms. I'll call her Ms. Christina, and other concerns that have been raised up. So I've read the pleadings submitted by the parties. So I'll hear first from you, Ms. Norris, then I'll hear from Mr. Evans.
I basically want to share custody like we agreed on, you know?
You said you want to do shared custody,
Well,
or you don't?
well, I do, but I'm worried about Christina, like with Brad and his mom coming to my house and telling me all the stuff that they told me about her.
Mm-hmm.
I mean, I'm sure you read, but
Mm-hmm.
I right now I can't even see my daughter. I don't even know where he lives. I don't know. I can't call her. He says, yeah, we can talk, and then he doesn't answer the phone. Like, I haven't had a visit with her. And then I run into them and they're living in a hotel. They're evicted from their house. I don't know anything about that. So I'm worried about my daughter's safety right now.
When was the last time you had visits with your daughter?
I had a video visit that he allowed on Mother's Day.
And prior to that?
Prior to that, I had her at my house every day for like 2.5 months until April 14th.
Okay, so April 14th was the last in-person visit.
Yeah.
And then you had a video visit on Mother's Day?
Yeah.
Okay. And in your motion, I want to just ask you a little bit, if you could help me understand. There was a third-party custody case where Lorena Cheryl was the guardian.
Yeah, that started when my daughter was like 9 and 6 months old. We were living in a car and Brad was abusive and she was afraid of her own dad. So I asked my sister if she would help me.
Okay.
I made the better decision for my daughter at that point.
And that guardianship case has ended?
Yes.
It's no longer active?
No.
Okay. And that ended in early 2023?
Yeah, whenever Brad got custody over, it ended.
Okay. And when you say got custody of her, what does that mean? Was there a custody order entered in the guardianship case?
I don't know. I don't understand all this court stuff. I don't know.
Okay. All right. All right. And then so you're wanting a 50-50 parenting plan with exchanges on Friday at 3 p.m.
Yeah.
Okay. And then if anybody becomes homeless, then the child resides with the other parent until they cease being homeless.
Right. But I just want her well-being first.
Okay. And then you mentioned the vaccinations. The child was behind in vaccinations.
Yeah, in the 2 months that I had her, she was not in preschool. She had like 6 or 8 vaccinations that she was behind on. I got her a new referral for her eyes because she has glasses. She can't really see. And in that 2 months that I had her, I got her into daycare. I got her vaccinations up to date. And then they denied me going to her eye appointment that I had got the referral for.
Okay. And so during the time of the guardianship, was the guardian in charge of doing any of those things, like the vaccinations and the medical care? Yeah.
Probably, but I mean, he's had her for quite some time. She should have been in some school or had her vaccinations done.
Okay. All right. And then you talked about Mr. Evans working out of town, and so it sounds like if he's working out of town, you wanted to have the opportunity to care for your child.
Yeah.
Okay. And then since the guardianship ended in like 2023, it sounds like you started having unsupervised visits with the child in February of this year. Is that about right? Okay. And then overnight visits started between that mid-February to about mid-April.
Yes.
Okay. And then during those overnight visits, was it a 50-50 arrangement, or was it just kind of here and there, a day or a weekend? Or
well, we had talked about it being 50-50, and he was in agreement with it. And then I had on my EBT renewal thing, I had if you have a change in your household, you have to put it down, and he took it as I was trying to screw him or something. I don't know.
Okay. All right. And then just tell me a little bit about your concerns about Ms. Christina.
I just Brad and his mom have both told me things about her. Like Brad would bring her to my house because he was afraid of leaving her with her. And one time Jody brought her to my house, and she said she walked in the house and Christine was like totally sleeping like out cold, and my daughter was just running freely and they're doing whatever she wanted. So she brought her to me. And then
how old's your daughter?
Huh?
How old's your daughter?
4.
4. Okay. Go ahead.
And he's brought her to me numerous times because he was afraid of leaving her with his own wife. And it's just the things that they've told me over that 2.5 months. That I journalized everything in there.
Okay.
It's just I just don't feel like she didn't even raise her own kids. So I mean, I don't feel like she's safe by what they're telling me and what my daughter's telling me. My daughter tells me that she's mean to her and that she had bruises on her hands from her. And the other day I seen them at their hotel when I didn't know they were homeless. I ran into them at a hotel, and she grabbed my daughter and she started running up the stairs like I was a stranger to her. And then they all 3 came down and let me see her for a minute. But like when I first pulled in, she like pulled her away like I was a stranger, like I was in danger to her or something.
What's your housing situation currently?
I've had my own place for 3 years.
Okay. All right.
She has her own room and everything.
And then at the base of the guardianship case, were there some parenting deficiencies on your end, or what was going on in your life that kind of led to that?
I had postpartum depression, and I was in an abusive relationship, and I was living in my car, and I didn't think that was a place for my daughter at the time.
Okay. Okay.
So
who filed the guardianship? Do you know?
my sister did.
Your sister did. Okay.
Mhm.
All right. Okay. Anything else? I kind of peppered you with some questions, but do you have any other input you want to provide at this point?
Just basically what I put in there. I don't have anything else.
Okay. All right. Thank you. All right. We'll turn the time to Mr. Evans. And Mr. Evans, okay, go ahead.
Yes, Your Honor. Well, so I would like to not try to fight off all the things that she said, and I just like to keep it short and sweet and just say, that we did everything that the judge required us to do to get grace. We did the treatment, we did that parenting classes, we did absolutely everything. And
what type of treatment was involved?
It was SUD.
SUD. Okay.
Yeah.
And when you say we, who's
we had Christina did the same thing. She was required to do the same thing. Pass hair follicle test, all that. And she was right there. Christina's been everything to Gracie. So
And then when the guardianship was in place, the child was placed with Ms. Norris's sister.
Yeah. See,
and then did you have visitation?
I did. I went through. There was phases to jump through. So it was started out with phone visits, right? Video visits. Then it went to supervised visits, then unsupervised visits, then weekend visits, and there was a few phases to go through. It took a lot. It took a lot of time, but all worth it. We did it.
And then when the guardianship was terminated, what was the court's indication as far as custody of the child?
So the paperwork just said that the father did everything that the courts required, and the guardianship was terminated. Now I was recommended to put in a parenting plan. I paid $500 for a parenting plan to get written up, but I didn't put it in. I still have it. As a matter of fact, I was going to put it in, and my mom said something to Summer about it, and Summer went and put one in. Anyways,
so at this point, there's no parenting plan.
There's no parenting plan.
And the child, it sounds like child has been principally with you with some visits with mom.
Yes. We recently just wanted to, give her some visits because she's a biological mom, and I figured maybe it would work out, right? And it just isn't. There's something missing here.
Okay.
As far as honesty is, concerned.
And then, can you address some of the concerns raised by Ms. Norris related to Ms. Christina?
Yeah, Christina's. I never said anything bad about Christina as far as Grace is concerned. I had a couple questions I asked Summer because Summer knew of Christina being with somebody before we ever got married. Now that's something that I would hope shouldn't even be on the table because it has nothing to do with Gracie. And I definitely have never had a concern with her and Gracie being together. I'm very thankful for her being with Gracie.
As far as her, Ms. Norris raised concerns about maybe some suicide attempts by Miss Evans, and then the passed out concern. Can you shed any light on that?
Oh yeah, my mom. So they were taking a nap. My mom came in. My mom's been kind of. She's got a little bit of issues, right? And I took her to my home, and because she's my mom, no matter what, I'd never turn her away. Well, she kind of stirred stuff up a little bit. She came in one day, and while they were taking a nap, and Gracie woke up, and she actually took Gracie to Summer's house without even letting my wife know. So when my wife woke up from the nap, it was definitely a shock to her.
Okay. All right.
Huge shock. She called me up. It wasn't okay for her to do that.
Definitely. You mentioned that you were required to do certain things in the guardianship case, and you also mentioned that Ms. Norris was required to do things, but she didn't do any of the things. Right. What things was she required to do?
It should have been SUD. Should have been mental health evaluation. All that stuff. Parenting classes. I did a 12-week parenting class that was 3 hours a week, and I did another parenting class that was 16 weeks long, an hour and a half a week.
I did parenting classes.
Okay, you did class. Okay, and Mr. Evans, can I pause on asking on your presentation just for a second to ask Ms. Norris a quick question?
Sure.
So, Ms. Norris, under the guardianship, it's represented that there were some requirements that were asked of you to do, like an SUD evaluation treatment, mental health evaluation treatment.
Yeah.
Do you want to speak to that?
I'm doing the methadone clinic right now.
Doing
And
methadone?
I have mental health. I started it through CORE, but I haven't really been. It's been up and down with my daughter. Like it's hard to do stuff when I don't have my daughter. Like.
Gotcha. Okay. All right. And then, so Mr. Evans, Ms. Norris has proposed a 50-50 parenting plan. What's your proposal?
I definitely don't want her out of her life. I want her in her life. But as far as 50-50 is concerned, that's just not. I'm not willing to do that. I mean, it hasn't been easy. To fight that battle, to get her, to get that guardianship terminated, and to pay. I got a family of 4 people. I'm only one working. I paid $28,000 a year in rent. I mean, I busted my butt for my family. There's no way I can just take a gamble.
If she's requesting a 50-50 parenting plan, what is your request for a parenting plan look like?
Every other weekend.
And Gracie's 4 now?
She's 4, yes. And I would want some sort of I would want somebody to kind of evaluate Summer with her, because I feel like Summer might not talk to her exactly right. When we seen her at the apartments or the motel, Summer was telling her sorry as we were leaving, like there was something wrong, and that's not okay for me.
She was crying. She wanted.
I understand that she was crying. I'm sorry. I'm not gonna.
She wanted to come with me, and I was like, I'm sorry, I can't do nothing about it. Her dad wouldn't let her come with me. After letting her come to my house for 2 months, he just took her away.
Okay.
She was in agreement with the 50-50, and when she's at my house, she doesn't want to leave. She says they fight all the time, and she's sad. She doesn't want to be around that.
Mr. Evans, are you working?
Yes, well, here and there, sir, I am.
Don't even have a home right now.
Okay, and Ms. Morris, are you working? I'm just asking for schedule purposes.
Oh, and I'm going through training right now, nursing training.
Okay, and what's the schedule on that?
It's online.
Oh, it's online training?
Yeah.
Okay, so there's no set schedule per se?
No, I'm open all the time.
Okay, and then Mr. Evans, what's the current status of housing with you?
I'm living with my mom temporarily.
So I'm directing my question specifically and only to Mr. Evans.
Okay, yeah, we're at my mother-in-law's house temporarily. My landlord sold the house, and so we're just temporarily here. Yeah.
And that you say that's your mother's home?
My mother-in-law, yes.
Mother-in-law, and where does she live?
In Kelso.
In Kelso, okay.
Yep.
Is Gracie enrolled in Head Start, preschool?
She's going to be enrolled in Head Start. As a matter of fact, I got the email today. She'll be starting the next school year. So, yeah.
Okay. Thank you, Ms.
She
Morris.
should be in a preschool or something before.
So you were saying, Ms. Norris, that you said previously she was enrolled?
The 2 months that I had her, I got her enrolled into a preschool. Yes,
Okay.
and she hasn't been going.
Okay.
So she didn't have her for 2 months straight. I was letting her have her quite a bit. Okay. She went and got food stamps for her without my knowledge, which is not okay because she's in my custody, has been for a very long time. And then before I knew that, I let her put her in the daycare. Well, that right there is all red flag to me. Obviously, she's going to try and pull something to get custody or something. So I didn't allow her to go to that daycare any longer. And I looked into Head Start.
CPS is the one that came over and got me the information to get her into daycare.
Okay.
It was not just me. CPS came over there and was working with me because I was the only one working with her.
No, actually, you weren't. I still have her number, and CPS told me that you were trying to get them to help you out. She's definitely not helping you out. So let's be honest here.
Help me out.
Okay, so there's certainly disputes between the parties. The one thing that is both of you, you don't do court on a regular basis. You're not professional court attenders, right? So court can be a challenging place to be. What I think I want to do, I want to appoint our family court investigator. Her name is Jennifer Schaefer. Jennifer Schaefer is, I just need her to come in and talk to you and some of the parties that you associate with and see what's going on with the child to give me a little better idea what's happening. And generally what I'll ask her to do is to meet with you and then she will investigate and just give a quick turnaround time about giving the court a little more information, because right now I have some information that's important and there's some question marks that I have that I'm just really not quite sure what's happening with the case. So I'm going to appoint her to investigate, and then I want to review the case on the 10th of July. So we'd review that on the 10th of July and make potential further adjustments to a schedule that I'm going to give you now. So this is kind of it's a stopgap measure because there's a lot has happened in this case. There's been a lot of issues with the guardianship and a lot of issues between the parties and concerns that have been lifted on both sides. And just making sure, Mr. Evans, you're still with me, correct?
Absolutely. I'm just writing.
Okay, good. So that's roughly about 4 weeks, 5 weeks until the next hearing. And as far as contact information, Ms. Norris, is there a best phone number? And if you don't feel comfortable sharing an open court, I totally get that. But
That's fine.
Okay, if you want, what is their phone number?
360.
And Mr. Evans, do you have a phone number that the investigator could use to contact you?
Absolutely. 360.
3365. Okay. great. We'll use that. And then as far as since April 14th, there's been limited visits. It sounds like just video visits for Ms. Norris. So I want to talk to you all a little bit about kind of a stopgap parenting plan between now and when we come back on July 10th. So this is what I'm thinking, is to allow frequent visitation between mother and child, and have custody remain with Mr. Evans until we come back on July 10th. And this is my proposal, and I'll hear input from you. Have visitation from Ms. Norris on Tuesday, Thursday, and Saturday from 10 a.m. to 6 p.m. And that would be the visitation. I recognize overnights are important, and yet when overnights happen, children are sleeping and there's not that interaction that we generally want parents to have with their child. So that allows for a lot of visitation and time during the waking hours. So I just want to hear from the parties if you have any strong concerns about that stopgap parenting plan until we come back on July 10th. Ms. Norris.
What days did you say?
Tuesday, Thursday, Saturday. The days don't necessarily matter to me. It's just I'm looking at 3 days a week.
That's fine. No overnight visits though?
At this point, I want to hold off till I get a little more information.
Okay.
And Mr. Evans, any thoughts on that?
I'm okay with that.
Okay.
Tuesday, Thursday, and Saturday?
Yeah,
From 10 to
Tuesday,
6?
Thursday, Saturday, 10 to 6. And then we would return on the 10th of July at 9 a.m. We'd have the family court investigator. You will have spoken to her each, and she will have written a report. I will have read that, and we'll kind of fine tune things and maybe make adjustments or do something with the case. So we have a little more information, so feel a little more comfortable about the case.
Okay.
So Ms. Morris, any questions at this point?
No, I just want to see my daughter.
Sure. Today's, so the next visit for you would be this coming Thursday.
Okay.
And then as far as an exchange location, is there a convenient place where you all could exchange the child? Is it
Wherever.
Hall
My
of
house,
Justice?
wherever.
Should we just say the Hall of Justice?
Yeah.
Okay, so we'll say the Hall of Justice will be the exchange point. And then Mr. Evans, any concerns about that arrangement?
No, there's not. Nope.
Okay, so I'll draft up this order and then get it out to you so you can see it. Hopefully by the end of Friday, I'll have that completed and you can look at it. Okay. All right, that'll conclude the hearing. Any final questions, Ms. Norris? Okay, Mr. Evans, any final questions?
No, not at all.
All right, we'll see everybody on July 10th.
Thanks, sir.
All right, thank you. That marks the end of the docket, according to the cases I had docketed. If there's anybody that was on the call who was expecting their case to be called, please let me know. Otherwise, we'll go ahead and end the docket for today. All right, we'll go ahead and end the docket. Thank you.